Did file this morning a memorandum dealing with proposed testimony of the defendants. I assume counsel have received it, and the people were also kind enough to cite to the court the case of People versus Wardlaw at 118 Calap 3rd, 375. Mr. Kuriyama, going back to the basics and refreshing my recollection, this was to my knowledge, the first California case that dealt with the dual juries. And in that case, a 1981 case, there was testimony by both defendants before both juries. The distinctions between that case and this are that, at least from the appellate opinion, there is no indication that extrinsic evidence was introduced before one jury and not the other relating to any matters other than the portion of evidence introduced by the prosecution relating to an extrajudicial statement of one defendant. Also, the defendants both testified in that case. However, unless I missed something, it's unclear as to whether that was over the objection of either defendant or at the request of both defendants. It's a little unclear. And it gets a little garbled in that at some point, one defendant, in the appellate court anyway, objected and complained that he somehow was deprived of the testimony of the other defendant, even though that defendant had testified. So it's the facts of that case are distinguishable and certainly unclear as far as the specifics of what occurred in that situation. But certainly it is precedent for defendants testifying before both juries. All right, let's get back to the people's proposal here that both defendants testify before both juries with certain limitations as outlined. There was something that the defense discussed with the court ex parte, and there was going to be some further amplification perhaps on that, but we can proceed with other matters at this point and get back to that. Let me hear, first of all, the response by, well, let me back up. There was another matter that counsel wanted to discuss, and that had to do with prior inconsistent statements and the use thereof to impeach a testifying defendant, and the defense argument that would constitute inadmissible hearsay. And since that relates to some of these matters that we would be discussing as to either defendant, let me inquire of the defense whether or not you have any authorities that you wanted to cite the court to in that regard.
Your Honor, I took a look last night at Nelson versus O'Neill, which was the case that the people were relying on for the proposition that on confrontation grounds that would be permissible to follow the procedure they were suggesting. And the thing about Nelson versus O'Neill, which stuck out upon a rereading, is the court's statement that the declarant co-defendant did testify in that case. He denied that the statement was made, and he was testifying at the request and in furtherance of the defense of the co-defendant. And the court says, Runnell, that's the declarant, the co-defendant declarant, Runnell's out-of-court confession implicating the respondent was hearsay as to the latter, and therefore inadmissible against him under state evidence law. The trial judge so ruled and instructed the jury that it must not consider any part of the statement in deciding whether or not the respondent was guilty. So under those circumstances, there was no denial of the right to confrontation, but here the people proposed to use statements made by Eric Menendez outside the presence of Lyle Menendez for the truth of the matter stated in those statements.
Well, let me just interrupt, and I'll certainly permit you to continue. Wasn't that trial conducted, the Nelson versus O'Neill trial itself in California? Wasn't that conducted prior to the Supreme Court's decision in California versus Green? By coincidence, the Nelson versus O'Neill case was a Los Angeles County case as well.
Nelson versus O'Neill was decided in 1971, and I don't have Green in front of me, so I'm not sure. Oh, actually, Green, California versus Green is cited in Nelson versus O'Neill. 399
U.S. 149.
So that case was decided before Nelson versus
Yeah, I understand the case was. You're talking about what the trial court instructed the jury, and my inquiry has to do with when that trial occurred in California in the trial court, as to whether California versus Green was the law or People versus Green, which had a different holding in California than the United States Supreme Court. I don't know. Perhaps in going through the details of the opinion we could find out, but this was a writ of habeas corpus proceeding through the federal court. So my guess is that the state court trial had been completed years before the matter ever got to the United States Supreme Court, and therefore it could very well be that Green was not the law in California at the time.
It may be, but I also know for the court that in Miranda, the co-defendant in that case testified and denied making the confession, and the court found a confrontation violation in that case. My point to the court in pointing out these distinctions is I don't think Nelson versus O'Neill solves the confrontation problem in the way that people say it does. It's not a situation.
Why don't you move your mic there?
It's not a situation where the court would be instructing the jury that the statement is only introduced as to Eric, and the people propose to use it for its truth. So I think the confrontation objection remains. And I think under Aranda, as I indicate to the court, identical circumstances where the co-defendant testifies, the court finds a confrontation violation, and I think Aranda is still the law.
Well, in my analysis, a testifying defendant is no different than any other witness, and the same rules would apply to a testifying defendant as any other witness. In the context that we're exploring here, that the testimony is before a co-defendant's jury, and he becomes a witness, and as such, when he testifies and is impeached by a prior inconsistent statement, why is his testimony treated differently than any other witness who walks in the door and takes the witness stand?
Because the non-declarant defendant, I think, for confrontation purposes, doesn't have the opportunity to cross-examine the statement that the prosecutor is bringing in at the time the statement is made.
Well, but that's the situation with a non-defendant witness. There is no opportunity to cross-examine an eyewitness or some other type of witness to a act or to any material issue in a case at the time the witness made the prior statement. The only time to cross-examine is when the witness is in the courtroom after the statement had been made. And in this situation, the defendant would be on the witness stand before both juries. He would be impeached by his prior inconsistent statement before his jury and also before the other defendant's jury. And the attorney for the other defendant has a right at that point to cross-examine him. And the defendant is sitting there watching the testimony and watching the confrontation and the cross-examination, and watching a cross-examination rather, and is a non-defendant witness was on the witness stand. What I'm trying to find out is what is the difference between a defendant witness and a non-defendant witness in this particular situation?
Well, one difference, and it's a difference recognized by the cases, is that the co-defendant, the declarant, has an enormous incentive to shift responsibility to his co-defendant, and the court recognizes that inherent unreliability in out-of-court statements in finding that hearsay statements by co-defendants are generally inadmissible. So the people are proposing here to bring in just such statements. In other words, Eric Menendez's statements to Oziel, for instance, shift responsibility to Lyle Menendez in a way that an eyewitness has no incentive to shift. And I think it's the co-defendant's position of trying to lay blame on the co-defendant, which makes those statements more unreliable and more subject to a confrontation objection than a non-defendant witness.
Well, but the case of Nelson versus O'Neill didn't hold the way you argue the matter. This holding is contrary to your position.
Well, contrary in a situation where the trial court instructs the jury that the co-defendant's statement is not being admitted against the non-declarant, and holds that as a matter of state evidentiary law, the statement is not admissible, and further where the co-defendant is helping his partner in that case. He testified in support of an alibi defense and said, I never made the statement, and we're both innocent. So that wasn't a situation where he was shifting responsibility. This is such a situation, and that's what makes it different.
All right, just quoting from Nelson versus O'Neill as it cites California versus Green at page 227 of the Nelson versus O'Neill opinion. Viewed historically, there is good reason to conclude that the confrontation clause is not violated by admitting a declarant's out-of-court statements, as long as the declarant is testifying as a witness and subject to full and effective cross-examination. Moreover, where the declarant is not absent but is present to testify and to submit to cross-examination, our cases, if anything, support the conclusion that the admission of his out-of-court statements does not create a confrontation problem. This is true, of course, even though the declarant's out-of-court statement is hearsay as to the defendant, so that its admission against him in the absence of a cautionary instruction would be reversible error under state law, is what you're referring to. But that is no longer the case in California, because California has adopted, number one, the Bruton view of things, and secondly, California versus Green. So none of those things apply. I understand your position, but I just conceptually have a great difficulty in distinguishing a defendant testifying before a co-defendant separate jury, and any other witness would come in and be subject to the same sort of impeachment, and such impeachment of a prior inconsistent statement would be received for the truth of the matter.
Stated our objections, and also from the court statement, I assume that this analysis would apply only if the foundation is laid for a prior inconsistent statement. In other words, it would require Eric Menendez to say, I deny making the statement, for there to be an exception to allow cross-examination about the prior statement.
Well, if he admits making the statement, I suppose he can be cross-examined about what exactly he says, and then it wouldn't have to be impeached. So one way or another, I suppose that the evidence might come before the other defendant's jury. I can't, I don't want to get into a situation where I'm going to evaluate all the possibilities here of what might or might not be said, and then give you an indication as to how a ruling would be made based upon some words that are going to be expressed during testimony.
I'm trying to focus on the court's analysis, which is that this is admissible as a prior inconsistent statement. And that comes up in the context of someone saying, I didn't make that statement. That's analogous, according to the court's analysis, of the Nelson versus O'Neill situation. And in that situation, the non-declarant co-defendant gets the benefit of the co-defendant stating that the statement is false. And then because the co-defendant is stating the statement is false under the court's analysis, the prior statement comes in as an inconsistency. But in a situation where the prosecutor asks a statement, didn't you tell Dr. Oziel whatever? And the co-defendant says, yes, I did.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
The non-declarant gets no benefit from that testimony. He's not helped by that at all. And at the same time, that question calls for hearsay, which is not admissible under any exception because there's no foundation for the prior inconsistent statement.
Well, as I said, it wouldn't have to come in that way because I assume the defendant or the declarant anyway would then relate all those things to the trier of fact and wouldn't have to be impeached. He would be saying all those things that were said to Dr. Oziel that Dr. Oziel testified about. If he denies saying those things to Oziel, then his prior statements are inconsistent. As you indicated, there is, or let me indicate to you rather, there is more than one way inconsistent statements can come out, and I don't want to be bound by any preliminary discussions here as to an exclusive way in which such statements can be brought out. Otherwise, I'd be giving you a commitment that only evidence can only be brought out in a certain way, and it wouldn't be fair to you and wouldn't be fair to the defendants in their testimony because there can be other mechanisms used for prior statements to be brought before the trier of fact, and I don't want to limit the court's rulings in that regard or limit the possibilities because I don't know what precisely is going to be said by anybody until they get on the witness stand.
Well, there's also another dimension to the problem, which is the prosecutor asks for a statement that is part of Dr. Oziel's testimony, which is inconsistent. And the co-defendant then seeks to bring out other parts of that statement, which are not otherwise admissible, except they're part of the same conversation. For instance, the co-defendant wants to bring out that Eric Menendez told Dr. Oziel that Lyle was primarily to blame for this. And that's perfectly consistent with his in-court testimony. There's no exception which would allow that testimony as to Lyle Menendez. It's not a prior inconsistent statement. And yet the co-defendant is going to want to bring out exculpatory statements which are incriminating as to Lyle Menendez and which do not otherwise fit within the exception that the court is relying on here.
Well, perhaps there might be an objection by somebody to the introduction of the evidence, and then the proponent of it would have to lay a foundation for an exception to the hearsay rule. I can't anticipate what the offer of proof would be or what the ruling would be. Certainly, this is a whole area that is ripe for controversy, and it's difficult to anticipate all of the issues that might arise. One other aspect that was raised yesterday before we get on to the memorandum filed by the prosecution was section 772D of the evidence code, and it was cited. And does counsel, any counsel, have anything further you wanted to add in regards to that? If anyone, other than reading the section, has anyone done any research on that in any way?
Well, just to indicate to the court that the court's comment yesterday was that section was designed to embody the traditional rule that the prosecution could not call a defendant to testify.
Or I'd expand that to one co-defendant can't call another co-defendant to testify.
And it seems that there are other sections of the evidence code which deal with the privilege of the defendant not to be called as a witness. So it would appear that that section would be unnecessary if that was its purpose.
All right.
Yeah, I would just like to note that evidence code section 760 defines direct examination, which I think takes 772B out, it makes it inapplicable to the defense argument. So,
Well, I think the tenor of that section is, as I described it yesterday, it addresses a situation where either the prosecution or a co-defendant seeks to call a defendant to testify on direct examination, but that situation would not here arise in that the defendant himself is calling himself as a witness. So he is the witness who is being called on direct examination. So that doesn't apply. All right, let's then go to the people's proposal and hear any objections. First, by the counsel for Lyle Menendez to the proposal by the prosecution.
Just in general, some objections. And of course, in stating these, we don't concede that the cross-examination proposal as to specifics is in any way proper. And I assume the court would get to the specifics.
Oh, absolutely. I'm not going to address
But
before the trial or before the testimony, I'm not going to address each and every area of cross-examination other than what touches upon the co-defendant and whether his jury is present. But I don't think it's necessary to go into all areas that the prosecution says they might want to cover during the cross-examination of the defendant before his own jury, because then we would be, in essence, litigating everything before the events arise. And I don't think that's necessary. I don't think anybody really wants that.
Your Honor, our general objections to this proposal that we alluded to yesterday are that it is prejudicial as to Lyle Menendez because it has the prosecutor dictating the order in which the examination of the defendant will take place, and it has a prosecution doing that in a way that highlights the most damaging aspects of the case which must be dealt with. That is, it separates out those areas of examination which relate only to Lyle Menendez and forces the defense to conduct its direct examination in such a way which will, in our view, unnecessarily highlight things which are better incorporated into a direct examination, which we would structure much differently. And in terms of the legal authority for our objections here, we did a little bit of work on this last night, and there are two cases which I wanted to bring to the court's attention, provide copies to the court. The first one is Brooks versus Tennessee. And Brooks versus Tennessee dealt with a rule which required the defendant to testify first in his case or not at all. Under penalty of preclusion, the defendant had to testify first. And the court struck down that rule as unconstitutional on two grounds: under the privilege against self-incrimination, and secondly, under the Sixth Amendment right to counsel. And the court's analysis as to the privilege against self-incrimination was that the privilege allows the defendant to decide without restriction whether he should remain silent unless he chooses to speak in the unfettered exercise of his own free will. And the court said that a rule that required the defendant to abide by a procedural rule which said he will testify first or not at all was restrictive. And the court cites a case which says whether he shall testify or not, and if so, at what stage in the progress of his defense, are equally submitted to the free and unrestricted choice of one accused of crime, and are in the very nature of things beyond the control or direction of the presiding judge. Control as to either is coercion, and coercion is denial of freedom of action. And the court then analyzes the question under the Sixth Amendment right to counsel and makes it clear that it's part of the right to counsel for the defense lawyers and in conjunction with the accused to decide how to put the case on. It's not for the court or the prosecution. And the court found that the procedural rule in that case placed too much of a restriction on counsel's choice to decide how the defense should be presented. And the court says at the very end of its opinion, while nothing we say here otherwise curtails in any way the ordinary power of a trial judge to set the order of proof, the accused and his counsel may not be restricted in deciding whether and when, in the course of presenting his defense, the accused should take the stand. And following up on Brooks versus Tennessee is a case, People versus McDermott, McDermand, which is at 163 Calap 3rd, 792. And in that case, the prosecution made a motion to defer its cross-examination of the defendant until after the defense psychiatric expert had testified. And the trial court allowed that procedure, and the Court of Appeal held that under Brooks versus Tennessee and People versus Colley, that was improper, and the court said this case would appear to fall within the ambit of the general rule that the order of proof in a criminal case rests in the sound discretion of the trial court. However, in our view, such discretion is not properly exercised, whereas here the trial court defers cross-examination of the defendant over a defense objection for the sole purpose of rendering the prosecutor's cross-examination more effective. We agree with defendant that such a ruling violates the underlying rationale of Colley and Brooks versus Tennessee by interfering with defense counsel's control over the presentation of his case and compelling the premature revelation of the precise nature of the defense. And then the court goes on to find that it's error but harmless. But I think as to the basic issue, those two cases are persuasive on the issue before the court as to whether the prosecution can dictate the order and the arrangement by which Lyle Menendez testifies in front of his jury.
Well, my reaction to your remark yesterday, as you reiterate it today and expand upon it, citing these cases, is that the defense in its examination of Lyle Menendez would have the discretion and unfettered discretion to break up that direct examination at strategic points to bring out evidence that it thinks is appropriate before its jury, and would not be restricted to a presentation that would require all of the evidence to be introduced before the two juries jointly, and then stop and address only those things that deal with matters that have been raised by the prosecution in its evidence before the Lyle Menendez jury only, and that have to be addressed only before that jury. And in that fashion, the defense would not be in a posture of highlighting certain matters. And I'm sure the defense would use its discretion as to how to go about this so that it doesn't unduly burden the process, but still I'd be inclined to permit that to occur so that you don't get into that situation. I can understand your position that you don't want to have everything packaged in one segment of testimony that would be totally damaging to the defendant and put him in a position to be isolated to defend himself at only one portion of his testimony, but you could certainly spread it out. And the mechanism is there for us to do that. We've had the juries go back and forth at various times, and all that would be required is that counsel make careful note of those matters that are being brought out and addressed in that fashion. As far as a cross-examination by the prosecution is concerned, that by its very nature would most likely focus on the negative things that the prosecution wants to bring out in the defendant's testimony, and whether that's brought out all at one time or segmented wouldn't really make any difference. It's still going to be the same thing. So I think the prosecution's cross-examination can be delayed until after the completion of the direct examination, and then segmented at that point, I don't think that's a problem, because the prosecution was going to try to bring out whatever negative information they can anyway during the cross-examination. So I think that would be a mechanism to deal with your objection or your concern. Did you want to comment, anybody, on that? All right, let's then go forward with the specifics of the prosecution's proposal, dealing with first, again, the proposal is that Lyle Menendez would be testifying first, and evidence being brought out through the direct examination of Lyle Menendez that was of concern to him, that these matters would have to be brought out during his direct examination to address things that have heretofore been heard only by the Eric Menendez jury. The people have isolated those things. Let me ask whether or not you've reviewed it to make a determination as to whether or not this creates a problem for Lyle Menendez and his direct evidence. Well, whether you're confused or not, I'm talking to the other lawyers here.
Matters only brought out in front of the Eric Menendez jury.
Yeah, but their concern was that during his examination, he might have to address things that would be brought out during the Eric Menendez cross-examination that so far the Eric Menendez jury only has heard. And the people have isolated those things that they will limit only to the cross-examination of Eric Menendez outside of the presence of the Lyle Menendez jury. So in reviewing that, is there anything here that creates concern that the Lyle Menendez counsel have to bring out, which then would relate to the direct examination of Lyle Menendez? Sure, sure. And then I'll do the same thing with counsel for Eric Menendez to deal with that.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
I wasn't exactly sure which area they were referring to, but I believe on page 2, number 2 is the area that they're talking about being in front of both juries.
Yes.
And with regard to that, they have the erasure of the family computer, and it was their expectation that they would address issues raised by the Hayman's testimony, which were obviously not in front of our jury.
I thought later on that in the prosecution's memorandum, they speak of that only being brought out before Eric Menendez's jury. They do on page 3, line 13.
Okay, I just asked you.
It would just be Mr. Whitcomb.
All right, so Whitcomb is before both juries in essence, with some minor variation.
We would obviously object to the post-crime spending by Eric being in front of our jury. That was put on through Heffernan and Valerie Hart and Marta Cano outside the presence of our jury, and I'm not sure who else, but certainly there's been no testimony in front of our jury with regard to Eric's spending. We haven't seen any of the witnesses, neither has our jury. We haven't cross-examined them. We haven't seen impeachment or been able to impeach them. So we would object to that. To the statements made to Dr. Oziel outside the presence of Lyle Menendez, specifically the statements made prior to his arrival on October 31st. And we would also object to the Calabasas burglaries, and I'm not sure exactly what is encompassed there.
I'm not either. I don't know what the prosecution indicates or how that would come out.
Well, if Eric Menendez were testifying and we asked him about his statement to Dr. Oziel, and did you in fact, or did you not tell Dr. Oziel that part of the motive for the murder was the mistreatment that you and your brother had over the Calabasas burglaries, for instance. I mean, that would be an example.
You know, I'm not sure. I mean, obviously, these are brothers and they're charged with acting together and did act together. But I'm not sure why Eric's state of mind or Eric's motivation is relevant to Lyle Menendez. It is possible that they could have committed an act together, but for separate reasons. And so whatever Eric's motivation may have been, I do not think that anybody has suggested yet that they share one brain and therefore saw the world the same. They had different experiences. They interacted with the parents differently, and they may have had different motivation. So whatever Eric's motivation may have been, I do not think it's relevant with regard to Lyle Menendez.
Well, obviously, it depends on what is brought out during a direct examination to some extent anyway.
I understand that, but I mean, assuming Lyle Menendez testifies that his motivation was A and Eric testifies that his motivation is B, they could have both had separate reasons for doing what they did. And so, you know, we would object to the statements of Dr. Oziel along that line, and obviously the Calabasas burglaries. And I'm still not sure what they're talking about with regard to the burglaries.
I'm not either. How did the prosecution expect that to be brought out before the Lyle Menendez jury?
Your Honor, I don't know what he's going to say. And if he says, if he admits making statements to Dr. Oziel, then the cross-examination will go one way. If he
If he
denies
being
it,
who?
Lyle Menendez. And if he denies it, then the cross-examination will go another way.
All right, you're saying, well, as far as the Calabasas burglaries in particular, did you have in mind particular statements that Lyle Menendez made about the Calabasas burglaries to Dr. Oziel?
Yes.
And that had to do with his state of mind at the time the homicides occurred? Okay. And that's then the proposal by the prosecution as to how that would come out. So what is the defense response to that? It has nothing to do with what Eric Menendez might have said, but as to what Lyle Menendez might have said.
Well, yesterday, they indicated that they were offering these burglaries under an 1101 Wheeler analysis in addition to the offer they just made. So my first question is, how extensive is the examination as to the burglaries? Do they get to inquire as to the details and go into the details for Wheeler purposes or 1101 purposes? Or is it just the fact that they mentioned the burglaries in the discussion of with Dr. Oziel on the issue of motivation?
Well, I don't know what their proposal is, but at this point, what we're discussing is the issue of the direct examination of Lyle Menendez and how it might be impacted by the testimony of or evidence relating to Eric Menendez and his testimony as to how you would respond to it during your direct examination. And the people's proposal is that this is really something that would come out during the cross-examination of the defendant Lyle Menendez in relationship to his own activities, and it doesn't really relate to Eric Menendez at all as far as his evidence. But this is something that the people would be bringing out specifically in regards to Lyle Menendez. So as far as the details of it, I don't know if we have to go into that at this point. We can certainly, if it's a significant issue, deal with it before it's brought out. But I don't think that's the purpose of our discussions right now. We're trying to decide whether testimony is before both juries or one jury.
One general objection we have to that proposal is that if this evidence was relevant at all, it was relevant in the people's case in chief. And I think it's improper cross-examination and rebuttal to save up this burglary issue for cross-examination when they could have offered it during the testimony of Dr. Oziel.
I'm not ruling on that. That's a valid argument to be made, and as to the merits of it, I think it should be addressed, and because of the prejudicial impact of such evidence, it should be addressed before it's brought out. But that goes beyond the scope of our discussion here relating to the testimony of the defendants before one jury versus two juries. So keep that in mind as a substantial issue that you want to bring up. I'm not going to rule on it now, but it certainly should be before it is addressed either in any fashion whatsoever.
Yeah, maybe I don't pretend to have total recall of all of the testimony. I don't remember Dr. Oziel testifying specifically that. Okay.
About the burglaries.
Not in regards to
Right.
Lyle Menendez.
So-
That's in the state. Well, whether he did or not, I don't recall. But
Okay,
it's in the statement according to the prosecution, and whether it is or isn't, again, is we can
Okay.
debate that. But that goes beyond the scope of our discussion
Right,
here.
well, part of the question is if it was in there, and then secondly, if it, and this we may need to deal with later, but in terms of the burglaries as they're listed, I have very little information about them, but I do not, and I don't know what the people are relying on in terms of what his involvement is, how many burglaries they think he's involved in, and what his role was. So I think that we do need to clarify that, but that may be at a later time.
Yeah, there's all sorts of issues, such as the fact that he was never prosecuted for it, and I don't know what evidence there is to connect him to it. There's all sorts of matters that we can discuss, but I don't think it is germane to our present discussion, because I'm sure we all want to resolve this so that we can get on to other things, resolve the issue of one or testimony before one or both juries. All right, so basically right now the objections are by Lyle Menendez on direct, things that you might be concerned with that might be brought out by the examination of Eric Menendez would be the post-crime spending statements to Oziel and the Calabasas burglaries. And anything else?
What's listed there, that would be the extent.
Okay, then let's go to the Eric Menendez counsel and those things that you feel will be brought out during the testimony of Lyle Menendez that you feel should not be before your jury.
I'm just focusing also on paragraph 3 on page 2. I think that's what the Lyle Menendez statement to Detective Zoller on September 17th. The Lyle Menendez statements to Howard Whitkin that were not before our jury. Yes, and the fact that he wrote a check to him. The post-crime spending by Lyle Menendez, about which our jury knows very little. The 17-page letter written by Lyle Menendez. The statements of Ms. Pisarcik, at which there is no evidence that Eric Menendez was ever aware of any of the things that she makes statements about. The statements to Dr. Oziel after Eric has left the session on October 31st. And any other matters, whatever that means, which appears on line 18 and a half.
Your Honor, I should add the September 17th
Yeah.
statement also. I'm sorry, I
Okay.
just missed that.
All right. Well, let me go back then. Is this basically all, so that once I start discussing these things, and no one's going to come up with something else that, off the top of your head anyway?
Yes, Your Honor.
Okay. Regarding the post-crime spending that has been introduced as to each jury separately, and the people have made certain elections, specifically as to the Marina City Club purchase of the condominium there, that people made an election for whatever reason to introduce that evidence only as to Eric Menendez, not as to Lyle Menendez. Other evidence has been introduced as to one or the other by witnesses who have testified only before one jury or the other jury. And this is post-crime activity that did require extensive presentation of evidence and rebuttal evidence by the defense. And because of that, the court would rule that that evidence would only be admissible as to the defendant before whom the jury he's testifying, his own jury, not the other defendant's jury. Regarding statements to Oziel by either defendant outside the presence of the other defendant, I would incorporate my remarks regarding prior inconsistent statements in general. And that basically addresses the complaint of Lyle Menendez. As far as Eric Menendez, there was brief statements regarding or testimony by Oziel regarding what Lyle Menendez said to Oziel after Eric Menendez left. One of them, I believe, is before both juries, and one is not, is my recollection. The one in the office was before both juries, the one down below, or vice versa. The one where they discussed with Oziel what they were doing down below, I think, is before both juries. We can research our notes and be certain of it by the time it arises. That, again, is conduct evidence that is very discreet and not the subject of any substantial extrinsic evidence. It's basically he did do it or didn't do it. He did say it or he didn't say it. And it's a reflection of his state of mind. Material point be appropriate area of inquiry to inquire about his state of mind just about the time these statements were made. And any prejudicial effect of such evidence is substantially or would be substantially outweighed by its probative value under Section 352. So if he denies making the statements, then it's subject to impeachment. If he admits making the statements, then it's evidence that is properly considered by a trier of fact in evaluating credibility of the declarant. Regarding the Calabasas burglaries, we've in Lyle Menendez, we've had some preliminary discussions of that, and before any such information is brought before the trier of fact, we'd have to discuss it further. Going to the Eric Menendez complaints, or I guess both defendants, regarding the September 17th interviews. Again, to the extent those constitute prior inconsistent statements, they would be admissible to impeach testimony of a declarant and would be the appropriate subject of examination regarding the defendant's post-crime conduct, which basically in this situation was consistent, both defendants. It's not really one defendant doing something extraordinarily different than the other in regards to this post-crime conduct and denying involvement in the crime and blaming it on others, and issues regarding the alibi, which primarily, as I understand it, would be efforts to cross-examine either defendant, declarant, and impeach if necessary by whatever tape-recorded statements were made. And again, this is a discrete piece of evidence. It's something that is documented on a tape recording and not subject to extensive evidence that has been introduced only before one jury or the other, so can clearly be used without any prejudice to either defendant by reason of evidence having been introduced only as to one jury and not the other, and both defendants certainly have an opportunity to have access to the tape recording of the other defendant. And the brief testimony of Detective Zoller, which basically was that both defendants were interviewed the same day at the same house. And so I don't see this as a matter that should be segmented to one jury and not the other. Regarding the statement to Witkin, you'll have to refresh my recollection as to the specific of it. I can review my notes that what was brought out before the Lyle Menendez jury versus the Eric Menendez jury.
Generally speaking, Your Honor, I haven't reviewed the testimony, but I do recall it. There was no conversation between, from what I recall, between Lyle Menendez and Mr. Witkin that was provided to Eric Menendez's jury. And if I recall, what Mr. Witkin testified to by way of conversation, statements of Lyle in front of Lyle's jury, where the direction to reload the computer and conceal the fact that there had been an erasure, his statements about why he was looking for a will, his motivation for having Mr. Witkin there, none of that hearsay came out in front of Eric's jury. All that came out for Mr. Witkin in front of Eric's jury was that he, in fact, did what he, if I remember right, I think I do, did what he did
Well, let me
to
back
that
up
computer.
or interrupt for a moment. Assuming Lyle Menendez testifies about this incident,
Yeah, I don't want him to testify about that incident in front of my jury.
I understand that, but it happened, and he can describe, if he does, what happened. What is your objection beyond hearsay? It wouldn't be hearsay if he's testifying about it. He was there, he saw what happened, and he gave directions to somebody to do something. So,
Well, because they'll impeach him,
it's-
I take it, I don't think I don't know what he's going to say about Mr. Witkin and the statements ascribed to him by Mr. Witkin, but my jury didn't have an opportunity to evaluate Mr. Witkin's credibility vis-a-vis those statements, what he exactly said, Lyle said, and being confronted. I mean, this is very different than the September 17th statement, for example, which is on tape. Or I think they know how Dr. Oziel recites statements. But my jury didn't hear anything about Lyle's behavior or his demeanor or what the statements were from Mr. Witkin in order to evaluate whether Mr. Witkin was accurately reflecting those. And so to bring out then through Lyle his answer to Mr. Witkin's allegations, either on direct or a combination of direct and cross, puts our jury at a disadvantage to evaluate whether the inconsistent statement is true, was truly made, was reliable, was accurate.
Moreover, Your Honor, Mr.
Explanation.
Witkin,
May Ms. Morrissey also address the court on this?
Sure.
thank you. Mr. Witkin testified as to varying explanations given by Lyle as to why he wanted this information. First, he said he wanted to find a will, and then when they say that the will wasn't there, he says, well, good, I really want to sell the computer, and that's why I wanted to make sure that it couldn't be retrieved. So it's a little bit more complicated than just evaluating credibility with respect to a simple request to retrieve something from a computer.
well, we're assuming certain things here. You are that there is going to be a contention by Lyle Menendez that there's anything inconsistent in his recollection than what Mr. Witkin says.
See, that's the problem, is I don't represent Lyle Menendez, and since I'm not calling him to testify in my jury, I haven't interviewed him about these things.
Yeah.
So I don't really know what he's likely to say. All I know is what the potential impeaching evidence is.
Well, certainly to some extent that can be dealt with if there is any need to impeach, and otherwise his direct evidence is there. Your complaint is that he'll be responding to what Mr. Witkin might have said. The jury does know of Mr. Witkin's existence, does know of the activities there, and further knows that so far there was a phone call from, or a message from Lyle Menendez to Eric Menendez about this particular incident. So it certainly seems as though this is an incident that the Eric Menendez jury knows about, and from what's been presented here so far, the Eric Menendez defense seems to intend to introduce some conversations that occurred between Eric Menendez and Lyle Menendez about that incident, because we've heard testimony about it already. So when that comes out, then doesn't Lyle Menendez become appropriate subject of examination on what actually happened? Why would you want to compartmentalize it to the extent of only what Lyle Menendez told your client rather than what actually happened?
Because I don't know what actually happened. I don't know if Mr. Witkin was telling the truth, or if his recollection was accurate, or if the way he characterized the statements was appropriate. And I had no opportunity to cross-examine him about any of those things. That's the problem.
Well, again, that situation is one in this context, and it's a very small area of examination before the Lyle Menendez jury on these particular subject matters. This is a situation where the jury will not, the Eric Menendez jury will not hear the characterizations of Mr. Witkin, will not know his demeanor one way or another. All they'll know is what Lyle Menendez says about it.
No, and what Mrs. Buzanich confronts him with from Mr. Witkin's testimony. That's my concern. Whatever Lyle may say that, I anticipate there may be. Didn't you tell Mr. Witkin thus and such? And didn't you hear Mr. Witkin testify to thus and such and that sort of thing?
Well, okay, let me hear what the people's position is in that regard.
It's the same as if Mr. Wiccan had never testified. First of all, what is the prejudice to Eric Menendez? If Lyle Menendez gets impeached with statements that he may or may not have made to Howard Wiccan, all that the Eric Menendez jury knows is that we are alleging that he made these statements to Mr. Witkin, and if we don't prove them up in front of Eric Menendez's jury, then they haven't been proved. So from the point of view of prejudice, they aren't prejudiced.
I think counsel's forgetting green. They come in for the truth if they're prior and consistent statements.
Well, but they're not coming in. No one's introducing them. There are only questions asked.
If they can't be proven, then the question shouldn't be asked in front of our jury because it would just call upon them to speculate
No.
about evidence we know the people are not in a position to prove up.
Well, no, they could call Mr. Witkin back.
Yeah, but they're not intending to do that.
well,
as we know.
They could. The issue is basically a question asked and an answer given. And that's the end of it. We discussed that yesterday. So in this context, I don't see this as an issue that requires separate juries to hear the evidence. I don't see it as a matter of that cannot be handled by cross-examination and rehabilitation and things that normally are done in impeaching a witness and rehabilitating a witness. In regards to, so I would permit that in front of both juries. In regards to the 17-page letter and Ms. Pisarcik, both of those matters will take a little bit of time to discuss. And it's now 12:08, and my proposal is to do it at 1:30 unless somebody has some other pressing needs other than to eat. Okay. Okay. All right. Then we'll resume at 1:30 and deal with those matters.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
Yes.
I wanted Dr. Saul Fairson, who may or may not be testifying in rebuttal, to come to court tomorrow to watch the testimony of Lyle Menendez. I told the defense that I believe there may be some objection, I don't know. But then there's a secondary problem, which is that I wanted to videotape the testimony of the defendants and the defense experts for use by me with our experts, but not all of our experts to come to court. We had made arrangements with Courtroom TV to take a feed off of their line and just tape it. And evidently, something went wrong, and the Radio and Television News Association decided that that was inappropriate, and they cut us off. So what I wanted to do is ask the court if we could set up a video camera in the courtroom tomorrow to videotape the testimony.
No, clearly not. That's part of the overall discussions that ultimately resulted in the court having the camera placed where it is in an unobtrusive location.
Well,
And I'm certainly not going to change that now with both juries in the courtroom and have an extra camera. The whole idea of doing it this way is that it doesn't interfere in any way with the jury trial. And as we all have observed, as far as the conduct of the trial in the courtroom, the camera is totally unobtrusive, and nobody pays it any attention whatsoever. As far as the positioning of it, I'm not going to have another camera brought in that would do just the opposite of all the efforts that we've been involved with.
Well, would the court be willing to intervene in our attempts to videotape from the feed that's being taken from the courtroom?
Well, I don't know exactly what the particulars are. I got a call yesterday around 5 o'clock or 10 to 5 from the court information officer indicating that there had been some controversy regarding the people without notice attempting to take a feed off of the equipment in the media room here, and that it apparently for the first time became known that people were doing it in the trial downtown.
It was done with the consent of courtroom TV.
Well, regardless of that consent, apparently the court itself did not know it, and there's been some controversy because of it. When you say it was done with the consent of courtroom TV, you're talking about here or downtown?
In both instances.
Okay.
That's my understanding.
Well, my understanding was that the court did not know about it downtown, and there was some controversy about it. I don't know the specifics. I'd have to know more about what the objections are from the radio and TV personnel, their organization, as to why they object, and hear from them if they want to pursue their objection. It seems to me that this matter is being televised perhaps over televised, because it's on 2 different stations here in Los Angeles. At night, the entire trial is televised on one station, and the courtroom TV has another station going. So don't you have access to it that way?
No, Your Honor. In fact, I've been informed that it's not televised in its entirety, that it's only edited, and that's their argument. That since it's edited, that which we are taking, which is not published, are outtakes, and therefore we should not have access to them.
Well, why do you need anything more than what is on the TV with Century Cable, which is broadcasting it in its entirety? It's not, other than whatever is muted during times when the court's not in session. It's my understanding it's being broadcast raw without any commentary.
I'll check into that. I just think that since the facilities are here for us to do it, that it would be much simpler, and certainly wouldn't violate anyone's rights for us to just go over to the media room and tape off the feed.
Well, it certainly wouldn't violate the defendant's rights, but I don't know what property rights or other rights the people who are objecting to your doing it might have that come into play in this. So I'd have to hear from them as to why they object. I can't just order it without hearing their position. So
All right,
if you want to give them notice that you want to have a hearing, and we'll have them come in and I'll speak with them.
all right, Your Honor, as to the issue of Dr. Fairstein attending, he won't be here in the morning, but attending part of Lyle Menendez's testimony for purposes of observing his testimony. Are there objections by the defense?
Well, they've had Dr. Vickery here during testimony of Dr. Oziel.
Correct.
Yeah.
Dr. Vickery was here for 2 days during Dr. Oziel's testimony, because I believe there's a provision in the code that allows an expert to view the testimony of another expert. I don't have standing per se to object to Lyle Menendez being viewed by Dr. Fairstein, but I would object to him observing the testimony of Eric Menendez. And I think some of it has to do with how many days do the people anticipate that Dr. Fairstein will be here, just for the defendants, for their experts also, so that he would become a sort of permanent fixture in the courtroom and then be called as a witness. And a fixture who will be seen, I assume, taking notes, etc., and then be called as a witness before the juries. And we would object to that extensive an exposure of him. I don't know what the people have in mind in that regard.
I think the other area of inquiry would be, in terms of the extensiveness of his exposure to the jury, would be whether he's going to be here for all of both defendants, direct and cross, whether he's going to be here for all of the experts as well, which would certainly place him in the courtroom for 3 weeks, maybe, prior to testifying.
Well, let me hear from the people as to what you expect.
I don't know that he can attend. It was my intention to have him view the experts as well as the defendants, but I think that's subject to his availability. So I don't know when they're going to be testifying, and I don't know when he'll be available. But that was my intent. In a perfect world, I would want him here for all of it.
All right. The only objection then the defense has is to the physical presence of the individual in the courtroom in close proximity to the one jury in the audience. Is that
Well,
it?
it also depends on what they anticipate him doing. Is he going to be passing notes to Mrs. Bazanich? Is he going to be in some way acting actively as a part of the prosecutorial advocacy team? Will the juries be seeing that kind of behavior? I think that would severely compromise his ability to be a witness. I mean, they can have him here, but whether they can call him as a witness, ultimately, I think is maybe the issue.
Well, I suppose they can run that risk if they choose to. Is it the defense intention to have your experts here during your client's testimony?
No, it was our intention to send them videotapes or transcripts or both.
It's our intention to have one of our experts here for Lyle Menendez's testimony.
And this will be a witness who will testify.
Yes. He would not be here for Eric's testimony. He would just be here for the time that Lyle was testifying.
All right.
Well, then I guess the objection runs both ways.
Well, if there is one, what I'll do is order that if the witness is present, that the witness would have to be situated as far away from the jury as feasible, and that there be no note passing during the course of the testimony.
That would be fine.
And likewise, if the defense wishes to have a witness who is going to testify, then you would similarly be in a position to have that witness here. There is an overriding interest by the parties in having witnesses observe the testimony and be in a position to evaluate that testimony and be in a position to then, if called upon, testify about those observations. And it certainly is a procedure that is sanctioned and used quite often in trials where the experts are permitted to be present during the testimony of other experts and witnesses about whom they will be testifying. So the defense objections will be overruled. As far as the TV taping, it would seem to me that that's probably a more satisfactory approach and more economical, but that's up to the parties as to how you want to proceed. If you want to pursue the matter through the hookup here, then you'll have to notify the appropriate agency and we'll discuss it further. But as I said, there is another approach, since it is being televised in its entirety, at least on some of the cable networks or cable systems here in Los Angeles. All right, anything?
Get back to the non-issues.
All right, then let's resume our discussions here. Just to go back for a moment, Mr. Burt cited Brooks versus Tennessee, and the thought occurred to me at the time he was discussing it that perhaps the defense was attempting to allude to the circumstance of the defendant Lyle Menendez testifying prior to the exact date in which his testimony was previously planned by the defense. Was that part of your argument or not?
It's really cited for a different purpose, although I do think it applies to that issue.
Okay, well, as the record indicates, the court has ruled only upon the testimony of those three witnesses that were proffered in the document filed by the defense for hearing on Monday of this week. The hearing actually occurred on Tuesday of this week. The hearing actually occurred Wednesday. And the motion had to do with the testimony of doctors or psychologists who treated Mrs. Menendez. And the court made specific rulings only as to those particular witnesses, that their testimony would be irrelevant at this stage, and the court would have no way of evaluating whether their testimony was admissible, since the offer was that it was only corroborative of the defendant's testimony, and therefore would only be admissible if the defendants testified in a certain fashion that made the evidence relevant and admissible, and there's no way of knowing that at this stage. and the court's ruling related only to those 3 witnesses, and that analysis stands even in light of the case cited by the defense. This is certainly not a situation where the court is applying some arbitrary rule, but analyzing the facts as presented to it and the evidence being offered as to whether it's admissible or not. And at this point, the court has concluded that that evidence is not yet admissible and has deferred ruling on whether it will ever be admissible until after the defendants testify, so that the court would have some basis for evaluating it. And the record also indicates that the defendant, Lyle Menendez, indicated that his testimony was to occur immediately after the testimony of those 3 witnesses, and that's where we are now. So that's where we'll resume our discussions. We left off with the 17-page letter, and the people wish to use that letter as to both defendants. And what is the objection by Eric Menendez to that?
Well, beyond a hearsay objection, I understand the court's analysis on inconsistent statements, but I don't think that the issue is with respect to inconsistent statement when it comes to that letter. I think it has to do with certain states of mind and attitudes of Lyle Menendez at a time after the crime that are not relevant in Eric Menendez's case.
As to the entirety of it, or just as to portions of it?
From what I can recall, it's I don't have it memorized right now, Your Honor, because as of yesterday, I didn't realize they were trying to use the 17-page letter against Eric, and I didn't bring the file down that has that in it.
Well, there's the people alluded to some portions of it yesterday, and one of them involved reference by Lyle Menendez to acknowledging that Eric Menendez had made statements to Oziel and Signorelli, and he forgave him for that.
Okay.
I'm paraphrasing, but then would that not be grounds for examination of Lyle Menendez as to what Eric Menendez had told him about his conversations with Signorelli?
I don't think you need a letter to ask him that. I mean, you know, if the people want to ask Lyle Menendez, let me just say one thing. Let's put that section, let's assume that section, there's some potential discussion about that.
Okay.
That might have some potential relevance.
Well, that's why I asked in general, are you objecting to the whole thing or just portions of it?
In general, I'm objecting to most of it, okay, if not all of it. Because I can't see how most of it, where Lyle is talking about things having to do with him and business and stuff from school and my impression of Lyle, discussions about other defendants in the jail. I don't see how any of that could possibly be relevant with respect to Eric. With respect to Lyle's statement about forgiving Eric concerning Oziel and Signorelli, I don't think his forgiveness of Eric per se is relevant either. Now, if the people want to examine Lyle Menendez about his state of, in other words, if the people want to examine him concerning his acknowledgement that he knows that Eric said something to Oziel or to Signorelli, they can do that in any event. They could ask him, you know, did your brother tell you he made a statement to Craig Signorelli? And did he tell you what that statement was? Okay. And I don't have a problem with that. But I don't think they need the letter to do that, is my point.
Well,
now, if he denies it, then they could impeach him with that section of the letter that refers to his state of knowledge that Eric made a statement to Signorelli and Oziel. And I wouldn't have a problem with that. It's just all the rest of it that I don't see how it connects to my client in any way, shape, or form.
Well, there are some things in that letter that I don't have information about. It was referred to in one of the lists that was provided to me yesterday, Darrianne Braun, and
Yes, there's that.
I don't know anything about that other than the name in that document.
Well, all I know is I think there's just the name is in that letter, and I don't think that if that makes it irrelevant, just because the name is in the letter, that makes it irrelevant.
Well, I don't know anything about it. Is this going to result in some extrinsic evidence being introduced about Darian Brown or Larry Pollock or somebody like that?
That would occur in front of the separate juries. Darian and Larry Pollock are listed on our rebuttal witness list, so.
But these would only be witnesses in front of Lyle Menendez's jury.
Just a minute. No, I think it would actually go to both of them on separate occasions, either or both of these people. So inquiry about that portion of the 17-page letter dealing with Darian, I think would best be done in front of the separate juries.
My understanding about these people, Your Honor, based on the discovery that's been given to us, is that in some manner or means,
Money was invested with either Darian or Larry Pollock or both, and that the bottom line is they ripped off the Menendez brothers for $40,000. I mean, that's all I know about them. They're some kind of promoters, i.e. con artists, and managed to extract money from one or both of the brothers and rip them off. And so where all that goes, I don't know.
And also, apparently, Your Honor, the transaction was between Eric Menendez and these two individuals. And Lyle Menendez's only alleged participation is apparently after the money was ripped off. He had a confrontation with one of the two individuals. And during that confrontation, according to the witness's own statement, it was Lyle Menendez's cousin who was taking the active part in trying to get the money back by some sort of threat being made to these two individuals. So it's hard to see the relevance of that as to Lyle or as to Eric.
Yeah, I don't understand what it's supposed to be probative of.
Your Honor, actually, I think I misspoke. I think that it should be presented in front of both juries, because what it was is that Eric Menendez made an approximately $40,000 advance for the purpose of promoting a concert. And if the court will recall in the 17-page letter, there's reference to a concert promoter. And ultimately, there's reference as well to Eddie Nash, who also has been involved in the concert promotion business. And then later on, what occurs is that Lyle Menendez, in the company of Glenn Stevens, Hayden Rogers, and it appears perhaps his cousin, Mr. Yanyo, go to another person involved in this promotion named Larry Pollock, and basically try to intimidate him to get the money back. And so that's the incident that we are referring to that connects in with the 17-page letter.
Okay, assuming it does connect with a 17-page letter, what is its relevance in this trial?
Well, I think that the picture that's been painted of Eric Menendez as not being interested in money and not being materialistic and he was going to give his money to the homeless people is countered by the fact that there's this $40,000 that he was seeking to invest.
Well, it's one thing to invest it. It's something else to get into this confrontation, other potentially criminal acts.
Well, Your Honor, it could be that the scope of the cross-examination about Darian, insofar as Lyle and his conduct with his cousin and his two friends, that might be properly only in front of his jury. But as far as the other aspects of this transaction and explaining what it is and asking Lyle Menendez, did your brother get involved in this investment? That should properly be in front of both juries.
but even this as an investment, what is the timing of this supposed to be?
I mean, at what point does the very thin line of logical relevance between spending money and killing in order to get the money to spend it, when does that thread finally snap? I mean, I don't think the people can demonstrate, because I don't think there's any paperwork bearing on this, when this money was supposedly turned over, when it was supposed to bear profit, if ever. But the bottom line is that what this mainly demonstrates is how these Sharpies took advantage of a relatively unsophisticated kid and got him out of $40,000. Now, to litigate that whole thing, I think under 352 has extremely low probative value vis-a-vis state of mind for the homicide, and brings in a whole rogues gallery of shady concert promoters, including apparently the people would like to get another rogue, Mr. Nash, into the gallery.
under the theory that if something is mentioned in a letter, it somehow therefore becomes relevant in this trial, and that doesn't make logical sense either.
Your Honor, may I say something?
Sure.
If the thrust of the evidence is to establish another form of spending by Eric Menendez, then it seems to me that it's evidence the people should have produced in their case in
Right.
chief in front of Eric Menendez's jury, along with whatever other spending evidence they produced. Now, I'm not sure I understand why we're suddenly coming in the back door that way, so that now it's in front of Lyle. Eric's spending is in front of Lyle's jury through some cross-examination because he wrote a letter in which this person's name is
Well,
mentioned.
I think the people, as far as Eric Menendez is concerned, people are indicating it's rebuttal to evidence that he wanted to give all the money away or made some.
Which isn't in front of our
No,
jury.
I understand that, but that's
Even
what
that's
the
not
people were
even in front
indicating.
of Eric's jury. What his aunt has testified to is that with respect to his inheritance, which of course he never obtained, he had a mind to set up a foundation.
Well, there was also testimony that the bulk of his money was sitting in some bank account when he was arrested, so that the inference was that he was not
No.
spending.
No, we talked about substantial money being available to pay the legal fees. That's all that happened to.
Well,
with
it went a little
respect to
farther
that.
than that.
I
But-
don't believe.
Well,
so.
we can,
But anyway, okay.
this is a real nitpicky type thing here. The specifics have to be related to testimony, but it is rebuttal evidence, if anything. And I'd have to hear further offer of proof before it would be admissible regarding Lyle Menendez at all. It doesn't seem to have any direct bearing on him. And I do agree with the defense position that just because something is in that 17-page letter does not necessarily make it fair game. And it's possible, I suppose, that the defense would seek to introduce that letter in its entirety. I don't know. I doubt it, but it's certainly a possibility. There's certainly things in that letter that support the defense theory as well as things that support the people's theory. So it depends on which side is using it and for what purpose. But at this stage, it would seem clear that the entirety of the document is not admissible, and the specifics of what is and is not admissible would have to be addressed prior to its use, other than those limited things that we have discussed regarding Signorelli and Ozeal. I'm sure there are many other things that the people will intend to use it for, and there probably are many things that it can be used for, but I don't think it's fruitful at this point to go through each and every page and each and every line of those 17 pages unless counsel feel it's absolutely necessary to do that at this stage.
Your Honor, I just conferred with my co-counsel, and he would prefer that this only be put on in front of Lyle Menendez's jury.
The entirety of the letter?
Yes.
Okay, well, whatever they intend to do, that would only be in front of Lyle Menendez. Okay, so then that completes that discussion. The other remaining item that I have written down on my list of things that counsel informed me of this morning is Ms. Pisarcik, and there was some additional information that had to be obtained in regards to that. And one of those things can, I think, be done right here and now, has to do with when the people have determined that you were going to use Ms. Pisarcik as a witness. When did you decide that you would use Ms. Pisarcik as a witness?
She was on, I believe she was on the original witness list.
I mean, prior to the commencement of trial?
Yes,
Did you inform counsel that you intended to use her as a witness in this trial?
yes.
She was dropped off the witness list
Well,
and then reappeared. I think Ms. Morrissey has the record on that, but she reappeared mid-August.
Yes, Your Honor. She was originally on the people's witness list that we received on March 1st, 1993. Just prior to jury selection in this case, the prosecution provided an additional witness list that was attached to the jury questionnaire. So I think we received it by fax around June 7th. That was the time we were finalizing the jury questionnaire. Ms. Pisarcik's name does appear on that. The next time we got a serious list of witnesses from the prosecution was just as the trial started. We got a document that was dated July 16th, 1993, with the approximate order of witnesses, and at that point she dropped off the list. And she doesn't reappear until the prosecution's rebuttal list as of August 16th, 1993.
Well, as of June of 93, she was on the list.
They've had discovery, they've had her sworn statements for months.
Okay.
They've had a copy of that since shortly after we obtained it from her.
We have had that.
And it was part of the motion that we filed on March 15th.
Right.
Statement number 2425.
Yes. And we were objecting to it at that time.
Right.
It was never reached. I think Mrs. Vizanich indicated to me at one point that she wasn't sure whether she was going to call the girlfriends or not. And then she's not on the list, and then she appears on a list later. So I think she was always there as a potential witness. I'm not suggesting that she wasn't. Whether they actually intended to call her or not seemed to be in flux until the document we got August 16th. And obviously the fact that they're on the list doesn't necessarily mean that the person, not everyone on the list is going to be called. So in terms of our letting the court know what problems surround it, and I'm not suggesting any misconduct by the district attorney at all. It's just in terms of when certain things triggered us giving the court certain information.
Well, from what is presented to me now, it seems that whatever problem existed was something that you would have been aware of prior to the commencement of the trial.
Well, the question is whether she was actually going to be called as a witness or not.
Well, if she was on the witness list, wasn't that a good indication that she would be?
She was certainly a potential witness. Mrs. Vizanich had indicated to me that she had not definitely decided the issue with regard to whether the girlfriends would be called, and that involved two different people.
She also said she was reluctant to call them.
Whatever. I think that there wasn't a definite. No, I know.
This is an issue that we don't know about, right? I mean, I don't understand.
Well, I think you can be made aware. I don't, if counsel feel otherwise, I understand your concern, but if you want to discuss it in a closed setting, we can do that.
Also, Your Honor, we did, when the people filed their motion in March, file a responsive pleading in April, which pointed out that if the people were going to use that evidence, that the defendants would request an evidentiary hearing on the issue, as the issue involves sensitive information protected by the attorney-client privilege. So that issue, I think, was joined when the people filed their pleadings, and they never pressed for a ruling, and the issue never got resolved.
And our position is slightly different because I don't.
Yeah, there's a difference and a
Right.
distinction, and that can be handled. But in doing so, it could very well just ameliorate the problem for the other defendant as well, potentially anyway. Hearing here that requires us to deal with a matter that has to be done in a closed setting.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
And the trial will resume. All parties are present. And there were some other matters that counsel for the defendant, Lyle Menendez, wanted to resolve prior to his testimony.
One thing I'd like to take up with the court, I know the court's already expressed its position, but that's with regard to Lyle Menendez testifying tomorrow. I had indicated to the court before that if I had all Thursday in which to get prepared, I could put him on Friday, which was, of course, earlier than I had intended to put him on, but that I would do that. Obviously, we were delayed several hours this morning in getting started because of the transportation situation with regard to Lyle and Eric arriving here. in a timely fashion. We spent the rest of the day litigating these issues. We still have more to go. And I'm just not going to be in a position to put him on the stand tomorrow. I'm not going to be ready. I needed a day where I could outline what the direct testimony is going to be, knowing which areas we're going into and which areas we aren't. I obviously have to fashion a direct which does not have the Eric Menendez jury coming in and out of here like a swinging door, which there's no way I could have done that before the court's rulings today. We have the other issue, which we've just discussed, and Lyle Menendez wants the opportunity to get additional input in that area, which the court has made a decision with regard to making available to him. And I bring it up at this point because obviously if anything's going to be done about the juries, that should be done as soon as possible. I do not see that there's any way that I can now outline a direct examination and have any opportunity to consult with my client before putting him on the stand if he's to take the stand tomorrow. I don't think I would be competent doing it. I could stay up all night and outline it, but that doesn't help me with regard to having time to spend with Mr. Menendez going through what the direct testimony is going to be. And I apologize to the court for the inconvenience. I understand the court's concerns. I just also feel that we've spent a number of years preparing this case, and I don't feel competent putting him on at this stage without at least a day to be able to pull exhibits and prepare adequately.
Well, the anticipation was that even had we gone through with the testimony of the psychologist who had examined or treated the mother, that as I indicated last week, my expectation was that Lyle Menendez would be testifying today. So this today was not a day that was just picked, or tomorrow rather, Friday. And it was not a day that was just picked out of the blue, but it was a day that had been discussed at least a week ago. And so to that extent, this is not something that is a surprise or should be a surprise to counsel. And in most respects, I have to believe that counsel has prepared this matter. You've been involved in it a long time and have had a lot of time to prepare. I'm sensitive to your situation and concerned about your state of readiness. But much of the evidence that has been indicated to me that will be produced will relate to matters that will not be subject to these hearings and rulings that we've been involved with today, that these are matters that are not in controversy and not really things that you would be taken by surprise by any of the rulings that we've had or discussions we've had. These are matters that you knew you'd be putting on regarding his earlier background and history and those things of that nature. Isn't it?
It's just that there are. Obviously, what I'm going to have to do is very carefully go through and make sure that the areas that are admissible only in front of Lyle Menendez's jury is grouped together, and the evidence admissible in front of both juries is in another place. And I was not intending to necessarily go chronologically in his life. And so there are areas that we might get to sooner. And I just have not been able to put them in the proper sequence without knowing what's coming in and what isn't, and who it's coming in front of, and whether it should be placed in the beginning or the end or the middle, so that we don't have juries coming in for 10 minutes and leaving for the next 2 hours and coming in for another 20 minutes. I'd like to accommodate what I know the court would like to have, which is that there's some logical flow of testimony in front of both juries, and then a period of time where there's only one, so that juries aren't, the second jury is not sitting around and just being brought in periodically. And I just, quite frankly, have not been able to organize that until these decisions have been made. And so I'm in a position today where I do not have my direct testimony outlined. And obviously, since I haven't written it, I can't go over with Mr. Menendez.
Could I add one additional fact, Your Honor, which is may very well be that pursuant to the discussion in chambers, that an independent person could advise that I be the one that conduct the examination, or something even more drastic. But I think at a minimum, the possibility would exist that Ms. Lansing would be removed as being the direct examiner to alleviate the problems we discussed. And we made an attempt over the break to get a hold of someone, but I think that issue really needs to get resolved before we go forward.
When you say made an effort to get a hold of someone, what do you mean?
We attempted to contact counsel that we had indicated to the court we had discussed the matter with, and left a message for that counsel to call the court. He's in another department in downtown Los Angeles. So we expect to hear from him by the end of the day to see if he would accept an appointment.
Well, in regards to him, I don't know if it really accomplishes anything other than what you yourself could do, Mr. Bird, in giving advice. What would we benefit from getting someone else who has been contacted by you and Ms. Lansing?
Just to have an independent counsel evaluate the situation. I think he is independent, and we certainly are not wedded to that person. He was just available and had been brought up to speed by us, so that he's in at least some position to understand the situation. But we don't necessarily need that person appointed. But the point I was making is that is an issue that I think Lyle Menendez has a right to consult independent counsel about, and it's something that may affect who conducts the direct examination, and certainly affects the substance of that direct examination. And pursuant to the discussion in chambers, I don't think we're in a position to make that judgment call.
All right, did the people wish to be heard on what we've just been discussing?
No, Your Honor. I think it's between the court and counsel in terms of whether or not the court wants to start tomorrow. One thing I just wanted to ask that just came to mind.
Yeah.
When we do this cross-examination, it's going to be a little bit of direct, a little bit of cross. Can I be advised as to the last time it's going to be direct in front of both juries? In other words, to know when it's going to end? Because what I may do is, if it's general impeachment, I may wait until I get to the last time to do the general impeachment.
Well, your cross-examination is only going to be at the end. You're not going to be doing cross as the defense stops and starts.
I wasn't clear on that.
Yeah, no, I indicated that.
So we're going to have the juries come back and forth, and then I'll do one cross in front of one jury, one in front of both.
Yeah,
Okay.
you'd start before both juries and then finish with the one.
Okay, thank you.
Yeah. All right, the issue is really whether or not the defense is going to be ready tomorrow to proceed with its presentation. It concerns me mightily that the matter is in this posture, that counsel are not ready to proceed, and other than these matters that we are discussing and have been discussing regarding evidentiary issues, the matter that has just come to the court's attention is something that really could have been addressed much earlier, and would not put us in this situation. In regards to the state of readiness, assuming you had until tomorrow afternoon, could you then be ready to proceed?
If my client would be available to me in the morning.
All right, well, he would be here, so he would be available.
I could probably start at 1:30.
All right. All right, well, I'm going to keep the jury coming in. I think it's a little too late to call all the jurors anyway to get them before there would be some who couldn't come in or couldn't be reached in any situation. So I'll have them come in tomorrow morning. and then we'll take a better, have a better opportunity to evaluate it.
Witness scheduled for tomorrow morning. The people have indicated they object to our calling her, but
Who is that?
her name is Mary Theresa Dominguez. I think they gave you a report.
All right. Well, I'll review that, and
I mean, she
you
doesn't
can.
have to come tomorrow morning.
Well, why don't you have the witness here just to be, for some evidence. If the witness is permitted to testify, you might as well do it. I haven't reviewed it, so I can't give you a determination as to how I would rule on the people's objections. All right, let's resume here with the objections articulated by counsel. Or let me back up and ask the defendant, Lyle Menendez, the lawyer that has been discussed by counsel. Is that somebody that you would agree to?
Yes.
I'm asking Lyle Menendez.
Oh, I'm sorry.
Well,
I don't know him, so I agree to him.
well, other than the fact that your lawyers have already spoken to him about this subject, which indicates that they have given him some information. Is that something that you feel would cause you to want to have someone else who is totally independent, has no knowledge at all about these matters? Or would you be satisfied with this individual? He's certainly a very knowledgeable lawyer in the field.
I'd be satisfied with him.
Okay. All right. Well, if counsel can pursue it, I can't tell you that I will appoint him, but at least you can pursue that and see what materializes. All right. Let's proceed then with these other matters. Which specific issues then do you object to, Ms. Lansing? You had articulated. Sorry, I guess Mr. Burt was going to do these. Okay.
The first area were the three burglaries, which were the Kingston, Ginsburg, and the Litz burglary. And I think the people have indicated that they don't intend to go into the Litz burglary, since that involved Lyle Menendez entering the house to return property which was previously taken by other people and therefore was not technically a burglary. Is that correct? So the issue remains with regard to the Princeton and the Ginsburg burglary. And I think Mr. Burt has prepared some argument with regard to these two.
Pardon me, can I make an offer of proof?
Yes, that would help.
Sure.
Okay. The two burglaries, the one in Princeton and the Ginsburg burglary would be officers and credibility of the people versus Wheeler. But in addition, I believe that this information will be usable during cross-examination of the defense experts, who I don't know what they're going to say, but I anticipate it has to do with state of mind and victimization and criminality. And in that regard, I think it's relevant as well.
All right. In regards to the people's cross-examination of Lyle Menendez, is something you would bring out during his examination? Did you commit such a burglary, or did you tell someone about it, or what is it that you, just in general?
Generally, did you break into this house and take some property? Did you break into this house and take some property?
And if he says no, what is it that you would be doing to prove otherwise?
Call witnesses to impeach them.
Is there some extrinsic evidence or independent evidence that he committed these crimes, even though the prosecution never filed charges against him?
That's correct. The Princeton burglary charges were not filed because he was already incarcerated in this case.
I'm talking more about the Calabasas burglary.
Charges were not filed because Eric Menendez basically pleaded guilty to them in order to pleaded guilty to the burglaries in order to keep Lyle Menendez from having to have a criminal conviction.
Well, but the prosecution apparently didn't file charges because they didn't believe there was sufficient evidence to convict Lyle Menendez.
That's correct, but there's also the statement of Dr. O'Dell, which is the evidence of identity and honor. So we have a good faith belief that he was involved in it.
All right. Let me hear from the defense.
Your Honor, this evidence would appear to be subject to the same analysis the court adopted with reference to collateral impeachment of Dr. Oziel under Wheeler. The Princeton burglary, alleged burglary, took place on April 24th, 1988. And the police reports concerning that incident, we have a copy of these. The court's certainly welcome to look at them, but they indicate that the police were called to investigate a break-in into a home that apparently Lyle Menendez used to live in, on Nav in Princeton, New Jersey. And a typewriter and several other items of office equipment were taken from the property. And the discovery provided by the prosecution, in addition to that police report, which just indicates that the matter was reported, has a statement by a person named Christopher Kodik, C-O-D-I-K, in which he apparently, under a grant of immunity, essentially confessed and said he was involved in going into the property with Lyle Menendez. So the people have no independent proof that Lyle Menendez committed this burglary other than the statement of this person who was testifying after a grant of immunity. And it does, litigation of this issue does raise the same collateral issues that the court placed great emphasis on in precluding us from cross-examining Dr. Oziel under Wheeler. It is not particularly probative given the fact that it's from 1988 and the people have no direct proof other than this statement by this person that Lyle Menendez was involved. And the same applies with respect to the Calabasas burglary. It would involve, that was a 1988 incident that Eric Menendez pled guilty to. It would involve us in litigating who was responsible for that incident. And again, a collateral issue when the people have many other avenues to pursue with respect to Lyle Menendez's credibility.
Do the people wish to respond?
I think it's far more probative that he was involved in these burglaries than it is that an accusation was filed against Dr. Oziel, which has never been adjudicated, which the court allowed the defense to use to impeach his credibility.
Well, no, that's not exactly true. We brought out the fact that he had an investigation, a complaint currently on file, which was proper and non-cumulative and not time-consuming. And in response to that, the people chose to litigate Dr. Oziel's culpability for several other things, and that opened the door to that. And then the court precluded further cross-examination on any specific acts under a Wheeler analysis. And the court quoted the portion of Wheeler which said that the court should exercise its discretion to prevent journeys into collateral issues, which is what appear to be, especially since the people have no direct evidence that Lyle Menendez was involved in either one of these burglaries. It would involve unnecessarily time-consuming litigation to prove up the fact that he was involved.
All right, is the defense analysis correct that the only evidence regarding the Princeton burglary is that testimony of a co-participant in the crime?
There's only some circumstantial evidence, which is that there was no sign of forced entry and that it was in fact a house on Mountain Avenue, which is depicted on one of these boards here, which was the former residence. So aside from that, that's the only direct evidence is the statement of Mr. Kodik.
Well, the problem is, number one, as far as the burglary in Calabasas or that has been alluded to here, the fact remains that regardless of the prosecution's analysis now that one defendant took the blame for the other, which could very well be what happened, the people didn't have sufficient evidence to file charges against the defendant at the time. They didn't do it. They filed against the other brother. And if you had filed against the defendant and obtained a conviction, then he would have had a prior felony conviction. But this was never even the subject of a criminal filing. And the concern is that, in essence, what we would involve ourselves in is presentation of evidence on collateral matters that would consume an undue amount of time and get us into trials of other issues. The court is not precluding all impeachment of Lyle Menendez. There's substantial evidence that we've already discussed in that regard, but this evidence, based on the offer of proof presented so far, falls within the category of evidence to be excluded under Section 352 of the Evidence Code.
There's one other question I have that spoke with Ms. Lansing about the fact that this issue is germane to the experts. And I believe she indicated that that's not in dispute.
No, I said that she's, what Mrs. Bazan said was she's going to she plans to get it in front of the experts. And I said, I'm sure that she's going to try, and I understand her theory, and you know, we're going to litigate it and the court's going to rule. I mean, I am not conceding that issue.
Well, I'm just wondering if I don't know what their experts are going to testify to. And so if the court is precluding cross-examination of the defendant, does that mean the court is precluding any examination on the issue of the burglaries with their experts or our experts?
All I'm doing right now is ruling on the testimony of Lyle Menendez, and I don't want to go beyond that because it's taking too much time just to deal with this.
All right.
So let's worry about next week's or the week after's, 2 weeks from now, whenever that witness arrives. Let's worry about it then. All right, what's the next issue?
Judge, the next issue was the cross-examination about the escape plans. And the court will recall that it ruled this evidence inadmissible on a consciousness of guilt theory. And at the time the court ruled it inadmissible, the court indicated it was not ruling as to whether it would come in on cross-examination. But the court did say in the course of its ruling that at page 3206 of the transcript, quote, "It's hard to envision how a plan to escape from the jail or just notes regarding an escape relate to theories of first-degree murder or voluntary manslaughter. It would be more pertinent on an issue of identity than it is on an issue of guilt." And it's our position that that analysis remains sound and that there is no relevancy to cross-examination concerning these alleged escape plans, and that whatever, even if there was some marginal relevancy to it, it's outweighed by the prejudicial nature of this evidence and its tendency to prove up bad character evidence.
What's the people's response?
People's response is that, first of all, the court hasn't heard the testimony of Lyle Menendez, and I think that if his state of mind is put in issue, and it appears that his entire lifetime state of mind is going to be an issue, that his escape plan, these escape plans are important. And one of the things I'd like to point out is part of the cross-examination is going to deal with the creation or the creation of the defense in this case. And I think that to that extent, the escape plans are relevant to that issue, as well as the 17-page letter which deals with going for a manslaughter versus taking responsibility. In addition, there are other things that I intend to cross-examine him on that are not listed here. And I'm just wondering, does the court want me to give the court a list of every area I intend to go into so we can litigate it beforehand?
No. No, and this could very well be one of those areas that we'll have to await developments as to whether it's the subject of cross-examination. The people's response is opposite, that one cannot anticipate every word that is going to be uttered by the defendant on the witness stand and then rule on what is and what is not appropriate cross-examination. Those remarks I made at the time I made them are still correct. But as far as what develops during cross-examination, we'll just have to wait, and I'm not going to rule on this one at this time. I don't believe that it has to be ruled upon. it's not going to be brought out before the Eric Menendez jury, which resolves that issue. As far as Lyle Menendez, before it is brought out, the prosecution is going to be required to give notice, and it'll be litigated prior to that point. I understand the defense wants to explore everything and diffuse everything during direct examination, but that's not always possible. And this would be one of those areas.
Judge, the next area is the 17-page letter, and is it my understanding from the court's prior comments that the court at this point is not ruling the entire contents of that letter admissible as to Lyle Menendez, and that the court would take it up on a question and answer basis?
Yes, because I don't know exactly how it will be used, and the people haven't indicated, and perhaps they don't know until they hear the direct examination. There are certain things that I can look at it and tell you appear to be appropriate, but others don't, and I just don't want to get into it now because those things can change depending on what the defendant says on direct examination.
The last four areas, the statements regarding to Jamie Pisarcik, the condo purchase, the tennis agreement, objection to those areas as being improper rebuttal, that those areas could have been and were not presented in people's case in chief and are at this point improper rebuttal and improper cross-examination areas. I realize court has ruled on the condo purchase, and also I believe the tennis
Yes,
agreement.
I think the court said that since that had not been presented, the Marina City Club was only introduced this to Eric.
I said the spending as to each defendant
Right,
would be as to
exactly.
each defendant.
All right.
That's separate.
Participation in that purchase and not Lyle Menendez, and that's the way it will stand.
But as to the
Excuse me, may I just give her?
Yeah.
But there may be an instance in which it becomes relevant.
Well, if it does, then you let us know, and then we'll deal with it.
But that's true with all these issues. I mean, if he gets up and talks about something, and I'm not going to just pop up and start asking about things that are extraneous to his testimony. That wasn't my intent.
No, but even here where I'm making a preliminary ruling because it's a subject that has been brought up, that if before you bring it up yourself in cross-examination, you are to give us notice so that we can discuss it, so that since the defense has expressed objection to it, and the court has given some indication of a ruling that it should be litigated again before you go into it. Certainly anything could come out during the direct examination that could cause the court to change its rulings on any of these matters. These are in limiting motions and rulings that can change. We can't anticipate everything that's going to happen. But I have to believe that the preparation of the examination will be such that they will avoid such landmines, but you never know. We'll have to wait and see. All right, what's next?
Is the court ruling on the statement regarding the BBC and the statements to Pisarcik as?
Well, as far as the BBC, I don't understand how that's coming in the testimony of Lyle Menendez. How is that going to be brought out?
I don't know. I have to hear him testify.
All right, you don't intend to bring it out at this point as you anticipate your cross-examination.
I really don't know. I mean, I can't say.
He doesn't testify. What if hypothetically he doesn't say anything about it? Then I think that's what we need.
Okay, well, you don't have any standing in this whatsoever, so
Well,
just.
but we have similar issues.
Okay, well, then wait for your client's testimony or the rulings prior to.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
To it.
Judge, just to give the court a little bit more of a context concerning the BBC, there is a statement in those notes concerning the BBC that people chose not to put that statement in.
Well, that's attributed to Eric Menendez, though.
I think there's also a statement attributed to Lyle Menendez or an Eric Menendez statement in the presence of Lyle Menendez that the court ruled admissible, and the people chose not to put that in their case in chief. And it's our position that that's now improper to sit back without item of evidence and to spring it on Lyle Menendez in cross-examination.
Well, as I understand, the people don't intend to do that. They would wait until something is brought out during his direct examination that would make it germane. And then,
I will approach for that.
okay. So that's how it would be. That, all right, what else?
Because we didn't, at the time the doctor testified. Production in and around the time he was testifying.
All right, but even then, the people have indicated that they did not intend to introduce independent evidence regarding the BBC movie to the Lyle Menendez jury. That was something to be introduced during the examination of Eric Menendez. So it would have no significance at this point. There would be no reason to bring it out unless the defendant brings it out in some fashion.
No, I can make an offer of proof. The defendant will not say anything about the BBC. There will be no statements concerning the BBC. And then it seems to me the issue is, can the prosecution at that point say, well, wasn't the motivation here something about the BBC? There will be no testimony by Lyle Menendez concerning the BBC. And given that offer of proof, I'm wondering whether the prosecution intends to bring up the discussion with Dr. Oziel concerning that statement. And if so, whether that's properly admissible.
Did you intend to do that?
Your Honor, I have no idea because I haven't heard his testimony. It appears that his testimony is going to be tailored around what I can and cannot prove instead of being tailored around the truth. And so I don't know precisely what I'm going to ask. And I don't think that every question that I'm going to ask should be previewed and ruled upon before it's asked.
Nobody is suggesting that.
Okay, well, I don't know. If he says that, I mean, I don't know what he's going to say. If he talks about the genesis of this idea is coming from someplace else, I may ask him, well, didn't it come from a television show? It depends on what he says. And for counsel to suggest that this is sandbagging, if you read the cases, they deal with pulling back a major part of your case, not talking about the genesis of this idea.
She said.
Excuse me.
Okay, just keep talking.
So I don't know precisely what I'm going to ask because I don't know what he's going to say.
Well, I'm indicating that the testimony concerning motivation will center on the defense we've been putting forth from the beginning. That is self-defense, heat of passion. He is not going to say on the witness stand that the motivation for these killings was anything concerning the BBC. So the issue seems to be joined at this point, and to feign, as a prosecutor is doing, that she has no idea what the defendant's going to testify to, I think is avoiding the issue. She knows what the general nature of the testimony is going to be because we outlined that testimony in our opening statement. We've been consistent throughout. And it then appears that she intends to cross-examine him concerning this BBC statement, which she says goes to the issue of motivation. And our objection is, if it goes to the issue of motivation and it's such an important piece of evidence, why wasn't it brought up in the case in chief? And why is it being improperly highlighted at this point in the case? It's taking unfair advantage of the rules regarding what evidence is properly admissible in the case in chief.
Well, I don't particularly see that, and we're losing sight of the potential testimony of Eric Menendez and his cross-examination before the Lyle Menendez jury regarding the same subject.
But we can't be cross-examining from the Lyle Menendez jury on that subject.
Who said that?
Well, they're not offering it in front of both juries. I will tell you, according to this pleading, they said.
No. The cross-examination of Eric Menendez in regards to what he told Oziel would come before both juries.
Well, no, they're saying the BBC movie.
That's the movie itself and its contents or whatever else the people wanted to go into during in regards to that. But the reference to what it was that Eric Menendez told Oziel is a prior inconsistent statement if he denies saying those things. And that's the basis of what he told Oziel was the genesis of the idea to kill the parents. So that's a separate issue from the independent evidence that might be introduced before the Eric Menendez jury only. So that's different. And So as I said, we're losing sight of that aspect of it. And I already ruled that the people could cross-examine Eric Menendez about those statements he made to Oziel outside the presence of Lyle Menendez if he denies making those statements, denies those things occurred, and these would be prior inconsistent statements.
But Your Honor, that evidence goes to Eric Menendez's motivation, and the court has ruled that's admissible on that issue. But this has to do with Lyle Menendez's separate motivation.
Well, again, we're talking about two different things. Cross-examination of Lyle Menendez as to what he might have told somebody, that's one thing. And as it's been related to me, this isn't even something that he said. It's something that Eric Menendez said in his presence. So it's not quite the same. And that is one potential piece of evidence. The other would be if the prosecution introduced testimony from Oziel about what it was that was said in front of Lyle Menendez by Eric Menendez. That's not what they're offering at this point. So when you talk about sandbagging, that sandbagging would be just that, the actual evidence itself, not cross-examination of the defendant about something. I don't know if it's admissible or relevant in cross-examination, whether he was present when Eric Menendez said something. I don't know that yet. I don't know. I haven't been referred back to that particular statement. It was something we discussed about 2 months ago, or before Oziel's testimony, and I'd have to focus on that again as to whether it would be admissible in any context. But I'm not, at this point, I think I'll accept the people's representation that they don't know if they'll use this at this point, and if they do, they'll give us notice.
The last area of concern is we would have an objection based on privilege, attorney-client privilege grounds to any cross-examination concerning the December 11th, 1989 session with Dr. Oziel. And the court has heard evidence on this issue. The people have presented their brief. We have presented our argument. I think that issue is ripe for decision.
Well, I don't believe it is, because there is another issue that would precede it, and that has to do with patient-therapist privilege. That only after that is waived in some fashion does attorney-client privilege become an issue.
That seems to suggest that the court is disinclined to uphold a claim of attorney-client privilege because.
No, I'm just not going to rule on something that doesn't have to be ruled on.
But the problem is, if we are at a point several weeks hence where the court grants the people's 1016 motion and finds that the patient-therapist privilege is gone vis-a-vis that session, and that the attorney-client privilege doesn't apply, we don't have any time to take a writ on the attorney-client issue.
Well, you don't have any time now either, because
Well, we do.
no appellate court would look at a writ that isn't ripe. And it wouldn't be ripe unless there was no 1016 privilege.
No, I think it's the other way around. I mean, I think the attorney-client privilege being the broader privilege and the more absolute privilege finally resolves the issue if the court rules in our favor. If the court doesn't rule in our favor, then you're right. The issue doesn't become
That's
ripe.
what I'm saying. That's why you're in no different position. You wouldn't be in a position to appeal this or take a writ unless both privileges were ruled upon. And the patient-therapist privilege isn't before the court at this point, and I don't know if it ever will regarding that particular session.
That's the last issue we have discussion of.
And by the way, if there are any other, I'm not indicating anything by this as to how I would rule. I'm just saying if there are any other cases that you wanted to cite in response to the people's brief, you could certainly do that.
Yeah, I've looked into that, Your Honor, and I am researching that.
They had certain issues they raised regarding dual purpose or something of that nature. I haven't researched it, and if there's something that you want to cite, I'd certainly like to see
I'm
it.
looking into that, and we'll provide the court with some cases.
Okay. All right. Anything else now regarding the testimony of Lyle Menendez? Anything else regarding anything before we proceed with possibly the testimony of this one witness tomorrow morning You mentioned some other witness that dealt with impeachment of Dr. Oziel. Is that witness available?
He might be, yes, Your Honor. We could arrange to have him here
All
tomorrow
right.
morning.
Is there discovery that has been furnished to the prosecution?
Yes.
Discovery of that witness from them.
Well, evidently he called the police department and said,
Again, an interview over the phone, which we transcribed, having to do with Oziel's crooked business practices in the Automax business, and that's how we know about him. And that's what we intend to offer his opinion, which he expressed very ardently to Detective Zoller, that Dr. Oziel was dishonest. So they know what we know.
The testimony would follow the same lines as Ms. Lucosi.
All right. Assuming the witness is available and assuming it's admissible evidence, then we can perhaps proceed with that in the morning as well, and still give Ms. Lansing an opportunity to speak with her client in anticipation of the testimony. Who? Of course. But as I understand it from what's been indicated, these are two fairly brief witnesses. Okay.
Yes, but the arguments and the struggles and the hand-to-hand combats over whether they get to testify often eat up hours at a time. So.
Well, since I don't know anything about Phipps other than what you just told me,
That's about it.
I'd be more than happy to spend time right now hearing your arguments, if either side has them, regarding his testimony. What is your offer of proof? What is people's response?
This witness had about the same amount of contact, perhaps more than Ms. Lucosi, that the nature of the contact was in a business context. In fact, the same business that she was involved in. And that based on his observation of Dr. Oziel in this business context, he would have an opinion that Dr. Oziel is very dishonest. And that would be the extent of the offer of proof. And in offering Mr. Phipps and addressing the issue of cumulativeness, I'm concerned, given the testimony that's been elicited so far against Dr. Oziel, and specifically his testimony that his own testimony that women seem to have this overpowering attraction to him and end up in difficult situations, that we need to rebut the inference that it's just a couple of women who have some sort of axe to grind against Dr. Oziel. And that's why I think Mr. Phipps would not be cumulative, because it then puts us in a position of saying that a number of people, and not just women, have some very strong opinions about Dr. Oziel's honesty or lack thereof.
All right. What is the people's response? Assuming the witness can establish a foundation of sufficient contact with and knowledge of Dr. Oziel to form an opinion as to his character trait for honesty or veracity.
after hearing this Lucosi's testimony, it appears there would be a number of people from the firm who could come and testify. The question, first of all, I don't remember Dr. Oziel testifying the way that Mr. Burke described.
Well, regardless of that, that really is.
I think it's cumulative, and I think at some point the court has to. First of all, Julian Smith is still on the witness list, and I think, and so as is Alex Curry, and I think at some point the court has to decide how much impeachment of Dr. Oziel is sufficient. And I think that we've already had a witness testify to the exact same business dealings as this witness would, and that potentially we could call other people, but we already had a witness on the project, and so it's cumulative.
Laura, just to distinguish Mr. Phipps from Ms. Lucosi.
Well, I don't want to have that discussion. Does the defense intend to call Smith and Curry?
Smith will be called not on the issue of character necessarily, but on other issues, foundation issues on statements that Dr. Oziel made. And we would intend to call Ms. Curry as a character witness as well.
And on other issues.
And how many other character witnesses would the defense be calling?
As of now, Your Honor, that would be it. We do occasionally receive information about Dr. Oziel, which does prove fruitful, but as of this point, I think that would be the extent of the character witnesses.
All right. Well, I would be inclined to permit that testimony if the witness can establish a foundation for the opinion. At this point, I'm not prepared to say it's cumulative. All right. As far as the other witness, what is the objection to Ms. Dominguez? Or
That the information, has the court read the report?
no?
Okay, well, the information is speculative at best and doesn't prove anything.
What the information is, Your Honor, is that Ms. Dominguez assisted moving the Menendez family into the Elm Drive house
in the fall of 1988. And while she was cleaning in the master bedroom, she came upon stacks and stacks of male pornographic magazines. Now, they may not directly prove anything, but they are certainly potential corroboration for the fact that one of the permanent occupants of that master bedroom was a male who molested his sons. And our experts would say that the availability of male pornographic material bears some tendency and reason to corroborate the claim of both defendants that their father engaged in sexual acts with them. This is a totally independent witness. She has no connection to the Menendez brothers, and she recalls these episodes, had reported it to a relative of hers shortly after making her observation, and came forward because she felt duty-bound to do so, although she's a very shy and timid person, because she remembered what she saw in that house.
All right. Did the people wish to respond to that argument?
Just briefly, it's just as likely those things have been confiscated from one of their sons. We don't know. It's speculation at this point. And so because of that, I don't think it's proper. It's inflammatory, certainly, but it doesn't point in any particular direction. And it's just as likely that that information could have been confiscated from someone as that it belonged, or maybe Mrs. Menendez looked at it, but it doesn't prove anything. And so we can speculate all we want as to whose it is and why they had it, but it doesn't prove anything, and it's very inflammatory.
Well, I suppose they can ask the defendants if it was theirs, and then they'll get the answer to whether it was confiscated. But I would assume if a mother had confiscated this material, she wouldn't be saving it up in her bedroom, which is where it was.
All right. Well, obviously, we have a limited number of witnesses from the household to testify about those events. I'll review the report and we'll discuss it briefly tomorrow.
Is the case?
All right. Be in recess until tomorrow at 9 o'clock. Represented. And is there some matter that counsel want to discuss before we proceed?
Yes, Your Honor. I believe that yesterday we were speaking about the witnesses. There's only one witness this morning, Ms. Dominguez, and we had an objection, and I think the court's now had an opportunity.
Yes, I've reviewed the statement.
And actually, it's Mr. Carrion's witness, so I'll stop talking.
All right.
Suspicions based on relevancy, Your Honor, and subject to 262. The report also contains a fair amount of speculation. You object on that case. 3 things.
Well, I assume the defense is not going to elicit information that relates to matters of speculation or hearsay. And the offer proof yesterday had to do with specific observations the witness made.
There's a couple of other things in this report. I asked the witness to testify about the conversation she had with Mrs. Menendez about Mr. Menendez's occupation, her observation of the defendants, and her description of the magazines, obviously, and her description of the shower without any speculation about it.
Well, as far as the shower, is that fixture in the house that was there when it was purchased?
Yes.
What is the relevance of that?
Not just that the house had, I don't think anyone else has described it, it had one of these very large showers, big enough to accommodate more than one person.
Is there some relevance to that in upcoming testimony?
Yes. And there's already been testimony that there was a family practice of the males showering together.
Well, that had to do a much earlier time frame.
Yes,
Is this,
there will be testimony that didn't end in the earlier timeframe.
okay. Right, people wish to be heard?
I just reiterate the objections that we made. I think this, the relevance is minimal at best, and the 252 is should be excluded.
Well, the relevance has been argued yesterday. It's really at this point a question of the weight of the evidence more than its admissibility. It does have potentially some probative value, and certainly there are weaknesses in it as far as the magazines, and there's no need for the court to delineate the quality of the evidence other than to say that potentially there is some probative value here, and in relationship to the stated position of the defense as to what the evidence will be during the course of the defense testimony, it would be potentially relevant, and therefore the people's objections are overruled. Are we ready to proceed?
Yes, sir. I would get Oh, there are other things, but not on this subject matter.
There is one thing related to the jury, which is we were informed yesterday there was some sort of a fictional rendition of this case on one of the late night TV shows, The Tonight Show, apparently, involving the defendants acting out the crime and making various statements bragging about their participation in the crime. And we're concerned that the jurors may have seen that, so we would ask the court to inquire specifically whether any of the jurors saw that rendition. I think it played about 4 nights ago.
Well, I would ask the court to ask the question in terms of whether any of them have been watching the Jay Leno show, The Tonight Show, and saw anything allegedly related to this case. My understanding was that it was a particularly vicious, satiric parody with songs and jingles and such.
All right, this is the first I've heard of it. Anybody else want to?
We have a tape of it. I haven't seen it, but I understand there's a tape available, but we heard about it yesterday, or the day before.
All right, any other requests in relationship to the jury?
No, Your Honor.
All right, after this testimony, what is the proposal?
Well, I have an argument I'd like to renew briefly, the reliance on the Brooks case, Your Honor, to present a different argument on behalf of Eric Menendez concerning the order of the defense. And I can make it now if you want to hear it, or we can wait till after we get this witness on and off.
No, it doesn't relate to the next evidence in this case, the evidence being Lyle Menendez, so it doesn't relate to that.
Well, but it does, because the order of the defense that I have chosen would be to put Eric Menendez on in front of Eric Menendez's jury before they hear from Lyle Menendez. Because for many reasons, but not the least.
Okay, all right,
That's my point. So we'll do it later.
We'll hear your argument. Other than that, the defense had requested some time. The court indicated you would have until this afternoon. Is there anything else other than that delay before we proceed? Other than
You know, we have some additional in-camera discussion with the court, sort of up to the court on that issue. Other than that, assuming that I have some time this morning with Lyle Menendez, that Mr. Burton has some time with him, and we'll be ready at 1:30.
Okay. All right, then let's have the jury panels come in. Let's, rather than have this one come in first, let's have the other one so that we can get them in about the same time. In the trial, both jury panels are back in the courtroom. To all of you, welcome back. Good morning. And we're ready to resume with the testimony. The defense may call its next witness.
Thank you, Your Honor. The defense would call Mary Theresa Dominguez.
Raise your right hand, please, to be sworn. You solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes, please.
Sit over here.
Would you tell us your full name and spell your last name?
My name is Mary Theresa Dominguez,
Dominguez.
Could you spell Teresa, please?
Theresa.
Mrs. Dominguez, what is your current occupation?
I work for Stater Brothers. I'm a department head there.
And Stater Brothers is a supermarket chain.
Yes, it is.
Do you have a sister who is also employed?
Yes, I do.
And what is your sister's name?
Her name is Linda Martinez.
And by whom is Miss Martinez employed?
Mark Slotkin.
And do you know what Mark Slotkin does, what his business is?
He deals in real estate and I forget the other part that he does, but
Does he also have a furniture company?
yes, he does. He deals in leasing antiques.
Now, to the best of your knowledge, in 1988, did Mr. Slotkin own a house
Yes, he
at
did.
722 Elm Drive in Beverly Hills?
Yes, he did.
And was there a time that you were aware that Mr. Slotkin had sold that house to a family named Menendez?
Yes.
Now, did you, at the time the house was sold, were you employed by Mr. Slotkin to do something with respect to his moving from the house?
Yes, I did. I was working there to remove all his belongings.
And were other members of your family working with you there as well?
Yes, my 3 children and my mother.
And over what period of time did you work for Mr. Slotkin at that home?
For a week.
And at the end of that week, what was the status of Mr. Slotkin's personal belongings?
Everything was removed. My sister had conducted an inventory of all his belongings.
And after Mr. Slotkin's belongings had been removed, were someone else's belongings delivered to the house?
The Menendez family had started bringing their things in.
Now, while you were working there packing up Mr. Slotkin, did you meet Mrs. Menendez?
Yes, I did.
And was there a conversation with Mrs. Menendez about your employment?
She asked me if I would stay and help her.
And help her do what?
Unpack.
And did you agree to do that?
Yes.
And therefore, when did you start working for Mrs. Menendez in relation to when Mr. Slotkin had his possessions removed?
The Monday following the weekend, I finished on Sunday for Mark, and I started on Monday.
And how long did you work at the house on Elm Drive for the Menendezes, assisting them to unpack?
I think it was a little over a week.
And at some point in that week or so period, did you have a conversation with Mrs. Menendez about her husband?
I asked her what her husband did for a living.
And what did she tell you her husband did for a living?
She told me he was a plastic surgeon.
And did she say anything about his practice?
Yes, she told me they came from Florida and they went to New York, and he had a good practice out there, and they decided to come to California, and that they were going to live in Calabasas, or they were living there, building a home there.
And then she indicated now they had moved to Beverly Hills.
Yes,
And did she indicate that he had had a plastic surgery practice in Calabasas?
Yes,
Now, during this week or so period that you observed, did you see Mrs. Menendez every day during that period?
I seen her almost every day.
And when you saw her, did she always or usually seem to be holding something in her hand?
Objection to rule.
Overruled, you can answer the question.
Yes,
And what was it that you saw her holding in her hand when you saw her?
a glass.
And was it an empty glass or was it a glass with liquid?
It had liquid in it.
And could you tell what the type of liquid was?
No.
And would you see her sipping from or drinking from this glass?
Yes.
Over that same period of time, did you observe Mrs. Menendez on the telephone?
Yes, she was on the phone quite a bit.
And did you ever see her making calls in a somewhat unusual manner?
She just seemed upset a lot.
Objection calls for speculation. Motion to strike.
Overall, the answer will stand.
Did you see her, or did you notice her leaving the house at any point to make telephone calls?
Yes, she would go out to her car and make phone calls.
So she'd make phone calls from the car phone?
Yes.
And to the best of your knowledge, at the time that she would do that, were the phones in the house working?
Yes.
During the time that you worked at that house, did you have an opportunity to see the layout of all of the rooms?
Yes.
And calling your attention to the master bedroom, did you observe the bathrooms that were attached to the master bedroom?
Yes.
And with respect to one of them, did you observe any feature or aspect of one of those bathrooms that was new to your experience?
Objection, irrelevant and vague as to time.
Objection sustained. Please rephrase the question.
Did you observe the shower in one of the master bedroom bathrooms?
Yes, I did.
And would you describe for the juries what that shower looked like?
Objection vague as to time, Your Honor. This was before the Menendezes moved in.
Sustained.
Was the shower in the same condition after the Menendez family moved in as it was before?
Yes, it was.
Would you describe what the shower looked like?
It was really long, I'd say, from maybe the end of the desk to probably about right here. And they had openings on two different sides, and it had maybe 8 shower heads.
It was larger than an ordinary shower?
Yes.
And based on its size, did it appear that more than one person could fit in it at a time?
Yes.
Excuse me, could we get an estimate of the?
I don't know, what were you referring to?
Just the length of it.
What
the
length? What were you pointing to?
The end of the desk, I
What do
believe.
you mean, over here?
Mm-hmm.
This right here,
Mhm.
what I'm pointing to?
Mm-hmm.
From here
Yes.
to where you are?
Yes, to about right here.
Oh, about 8 feet or so.
Now, do you recall a day when you were working at the Menendez home when you came across some printed material in 2 different locations in the home?
Yes.
And would you first tell us what were the 2 different locations where you noticed this printed material?
In the master bedroom, on window seat, and on the floor.
And was there another room in the house where you saw similar printed material the same day?
In the library by the entry.
Now, this library by the entry, you notice this courtroom is what we call paneled. It has wooden walls.
Yes.
And did that library by the entry also have wooden walls, paneled?
Yes, it did.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Now, would you describe for the members of the juries what the nature of this printed material was?
It was men.
Objection vague as to which printing material she's speaking about at this point. I believe there's master bedroom and also the library.
Yes, you can be more precise.
Was the printed material both in the master bedroom that you observed and in the library of the same type and nature?
Yes, they were.
And would you describe what these things were?
It was males. It was pornography.
And it was pornographic what? Magazines, books, what?
Magazines.
And it depicted what sex?
Male.
All males?
Yes.
And did it show males doing things with other males?
Yes.
What, without getting graphic, what kinds of things?
Having sex.
Okay. And if I could focus your attention on the materials that you saw in the master bedroom, approximately how many of these magazines did you see?
There was a box, and it had stacks about, I'd say, maybe this high.
If you hold your hands up so the judge
About
may see.
this high.
When you say a box,
2
was
inches
it,
or so, 2.5 inches.
Probably more than that, a little more than that.
3 inches.
Was it like a packing box?
Yes, it was.
Let me show you something, just as an example. I'm holding a box right now just for size purposes. How would this box that I'm holding, which, Your Honor, just as a standard Fellows Archive Bankers type box, how would this box compare in size to the one that you saw in the master bedroom?
The other was larger.
Larger than
Yes, because they had magazines laying flat, and then they had some that were on the side, and maybe a few videos that were in there.
There were videos in the box
Yes.
as well? Mm-hmm. And were all the magazines that you observed in the box of that same sexual nature?
Yes, because I kind of went through a few of them.
Now, turning to and now strike that. Apart from the magazines and videos in the box, were there also magazines on the window seat?
Yes.
And were they, from what you could observe, also pornographic magazines?
Yes, they were the ones I looked at first.
And all of the magazines that you noticed were male on male sex?
Yes.
Now, turning your attention to the materials in the library, were those also magazines of the same type?
Yes.
And what size stack of materials did you see in the library?
There was just one stack in there.
And did it appear to be all magazines?
Yes.
And did it appear to be the same type?
Yes.
Now, later on the same day in which you observed these magazines, did you notice that they were gone?
Yes, they were.
Was Mrs. Menendez at home, the Elm Drive house, when you made your observations of these magazines?
Yes, she was.
Now, on one of the occasions when you were, one of the days when you worked at this house, did you see Lyle and Eric Menendez at the house?
Yes, I did.
And on that same day, did you see their father, Jose Menendez?
Yes.
And would you tell us what behavior, what activity you observed on the day that you saw both Mr. Menendez and the sons?
They were going outside to play tennis.
And who's they?
The father and the sons, and the mother was going to join them.
And how do you know they were going outside to play tennis?
Mrs. Menendez told me.
And did you see the sons and the father inside the house and exiting towards the tennis court?
Yes, I did.
And did you observe the demeanor or the looks of the sons at that time?
Yes, they were very sad. They looked like they were going to a funeral instead of going outside to enjoy themselves.
All right, objection sustained. The answer is stricken. You can rephrase the question.
Thank you. You've indicated they looked sad.
Yes.
Are there other adjectives you could describe without making an analogy to describe what their demeanor was? Did they seem lighthearted or serious? Did they seem frivolous or solemn?
Solemn.
Now, at some point after you had made this, well, we'll strike this. At some point, did you learn that Mr. and Mrs. Menendez had died?
Yes, through my sister.
Through Linda?
Yes.
And at some point before you learned that they had died, do you believe you told your sister about these things that you saw in the house?
Objection, hearsay.
Objection sustained. As to the form of the question, it's also vague as to what.
I'll withdraw that question, Your Honor. Mrs. Dominguez, did you
with recently put in process a string of events resulting in the defense in this case being contacted? No, I'll rephrase the question. Did you discuss your observations recently with your sister?
Yes, I did.
And was this the first time that you had told your sister about the magazines, or do you believe you had told her earlier?
I told her earlier.
And do you believe you told her before Mr. and Mrs. Menendez were killed or afterwards?
Before.
I have nothing further on.
Any examination on behalf of Lyle Menendez?
No, Your Honor.
All right, cross-examination.
Thank you. Mrs. Dominguez, you indicated that your sister works with a man by the name of Mark Slotkin,
Yes.
and she's been working with him for some 23 years, is that
Yes.
right? Does she work at the furniture business?
Yes.
And how long has she been working there?
Well, that business hasn't, well, it's been there almost as long, but she started with a handbag manufacturing company that he started.
This furniture business, is it located in the downtown Los Angeles area?
Yes.
Are you familiar with Eric Menendez's girlfriend, Noelle Terlesky?
Your Honor, I'm going to object to the form of the question. It is it assumes facts, not in evidence, calls for
Rephrase the question,
speculation.
please.
Are you familiar with a woman by the name of Noelle Terlesky?
No.
Did your sister Linda ever mention
Objection,
that?
hearsay.
Mention what?
Mentioned that Noelle Terlesky works at
Objection,
that business?
hearsay.
Objection sustained.
Your sister actually works at that location?
Yes.
Now, when is it that you first spoke to anyone on this defense team about what you're testifying to today?
I'd say about a week and a half ago.
And the first time you were ever interviewed was on September 6th, is that correct?
Yes.
So you never told the defense team or anyone else about this, is that right?
Objection, Your Honor, misstates the testimony.
Overruled.
Is that correct, ma'am?
No.
You never told the defense about this until the 6th of September, is that right?
I talked to my sister, and my sister talked to someone for me.
So your sister got a hold of the defense,
Yes.
and then your sister then got a hold of you?
Yes.
Did your sister ever mention that she had spoken to anyone that she worked with at Mark Slotkin's furniture shop in Los Angeles?
Objection, Your Honor, I think that's pretty vague. I'm sure she's talked to somebody.
Okay, counsel, let's not expand beyond the legal objection. All right, objection sustained. Rephrase the question.
What discussion did you have with your sister about getting in touch with the defense in this case?
I told her I remembered about the magazines, and I felt I really couldn't sleep at night. I was thinking about it all the time, and I didn't know if it was of value. So I asked her what I should do.
Now, what prompted you to think that this perhaps was relevant?
Because I was getting ready to go to work in the morning, and I was listening to the radio.
And when was this?
This was, I'd say, 2 weeks ago.
Had you ever heard about this
I'm
case?
not sure the witness had finished her answer, Your Honor.
All right, objections overruled that she had responded to it. Next question, please.
Thank you, Your Honor. Had you not heard of this case prior to 2 weeks ago?
Yes, I've heard of it.
In fact, you knew when the Menendezes were murdered. Isn't that correct?
I'm going to object to the use of that word, Your Honor.
Rephrase the question.
You were aware when Mr. and Mrs. Menendez were shotgunned to death.
I'm going to object to that characterization.
Overruled.
Is that correct?
Yes.
And that was 4 years ago?
Yes.
And had you been following this case at all?
Not really.
When you say not really, what do you mean by that?
I mean, I heard what happened to the parents, and I really don't get to watch TV or anything, very often. So I'd hear a little here and there. And it wasn't until I had heard about the children being abused.
Now, when was that?
Oh, I really can't remember when I started hearing about that.
Would you say that it was months ago that you had heard those claims?
I really can't say that it was months ago. I really don't know.
How did you get your information? Was it through the television or through the newspapers?
It was the radio.
The radio.
Mhm.
So you listened to a particular radio
Yes.
station?
Yes.
What is that?
It's called the Cat. It's a Western station.
And periodically there would be reports about this case?
Yes.
And at some point you heard that the brothers were claiming abuse?
I'm going to object to the form of the question, Your Honor.
Overruled.
Is that correct?
I heard that the father had been abusing the children and that he was showering with them. That's when I remembered.
Okay, you heard that on the radio.
Yes.
Now, at some point, did you talk to your sister right after you had heard this on the radio?
Not at first.
Not at first.
No.
When was it that you first spoke to her?
Oh, I guess it was maybe a couple of days later because it was eating at me. I just kept thinking about it. So I talked to her and told her, and she said,
I'm going to object, Your Honor, to what the sister said.
Your next question, please.
Anyway, you had a discussion with your sister.
yes,
Did you ever go to the furniture store in Los Angeles?
I've been there before.
You have been there?
Yes.
Have you seen Noelle Terlesky there?
No, this was a long time ago.
How long ago?
The last time I was there, probably when I did that job for Mark.
In 1988?
Mhm.
Now, you indicated that you did this job for Mark Slotkin, correct?
Yes,
And he was the owner of the house in Beverly Hills at 722 North Elm.
yes,
Now, were you aware that he had rented that house?
yes,
Okay. And were you aware that he had rented the house to Prince and to Elton John?
yes.
Now, when you were helping Mark Slotkin move, were all the furnishings in the house?
He had men moving things out, but there was some things that were kept that they were purchasing, the Menendez family.
Certain pieces of
Furniture.
furniture?
Mhm.
Were you mainly there to do cleaning? You've indicated that you were in the shower.
Hmm.
Were you cleaning?
Yes,
Was that the main purpose of why you were there for this period of time, that you were cleaning up the house for the new people that would be moving in?
and packing. I was packing for Mark also.
Now, what were you packing at that time?
Oh, different things from the kitchen to the bathrooms to, I was just removing everything that was his there.
With respect to the master bedroom, was there a window seat?
Yes, there was
in
two.
that- Two in that master bedroom?
Yes,
Was there some cabinet space underneath the seat?
I don't remember.
So you don't remember removing anything from the window
Cabinets?
seat, correct?
No.
Okay.
I removed whatever was in the bedroom.
But you don't remember about the window seat?
No.
Okay. Now, if there had been magazines left by either Prince or Elton John that were perhaps in this area, then you wouldn't have known about that, correct?
Your Honor, that's argumentative with also speculation.
Rephrase the question as far as the area you're referring to.
Yes. You've indicated a master bedroom, correct?
Yes.
And you've indicated that you saw on one day some magazines that you indicated had males performing sex acts,
Yes.
correct?
Yes.
Now, in that area, was that in the window seat area that you saw that?
Somewhere on top of the window seat, and there was a box on the floor.
Now, you don't know what happened to those magazines afterwards. You didn't see them after you saw them and actually looked at them.
I looked at him and I went downstairs to check on my son to see what he was doing. And I didn't want him to go in that room because I didn't want him to see it. I was concerned about him viewing any of that.
Now, you actually took a look at these magazines?
Yes.
More than one?
Yes.
How many did you look at?
I just randomly flipped different pages, different magazines to see if they were all the same.
Okay, so you went through every one of the magazines?
Not everyone.
But they appeared to be of the same type?
Yes.
Now, the magazines that you say were in the library, you indicated that they were, I believe in the report, that they were near the doors to the library.
That mistakes the testimony.
Rephrase the question, please.
Where did you see these magazines in the library?
There was like a bar in there, that type of thing, right by there.
Were they in a box or were they just out?
No, they were
loose?
just out.
Were there any other magazines around?
Before there was.
Okay. Did you look at any other types of magazines or just the
Yes.
ones you did? Did you go through all the magazines in the house?
Just the front, just like Architectural Digest, that type of magazine.
Okay, what other types of magazines did you look through?
Just on furnishings and things, just of that nature.
Now, the magazines that you had looked through regarding what you've indicated appeared to be males
Yes.
and sex acts. Were those magazines in the library or were those more like Playboy magazines?
No, it wasn't Playboy.
You know what Playboy is?
Yes.
Okay. These magazines that were over by the bar area, where exactly were they? Were they in a neat stack or what?
I can't remember if they were in a neat stack or not.
Okay. But you looked at those as well?
Yes, because it looked like the same thing, so I didn't want my son to go in there either.
Okay, so when you saw them, they were away from the architectural magazines that you had seen. Is that correct?
Yes, because it was the week previous that I was removing those, packing them.
You were removing what?
Magazines.
Okay. And you removed architectural magazines?
Yes.
That belonged to whom?
I assumed Mark.
These magazines that you found, or did you clean out the bar?
I cleaned the bar. I cleaned the library. I went through all the rooms, actually, is what I did. And my kids were removing things, and I would check up on them to make sure they were, doing the
With
job.
regard to the bar, did you personally clean out everything in the bar? Were there drawers and shelves behind the bar?
There was a wall unit that I remember, and I opened all the doors. My sister was telling me to go through everything because she did an inventory, and I was to remove everything that was there.
And at that time, you saw these magazines?
No.
No. Now, how many magazines did you see in the library, ma'am?
I'd say it was a smaller stack. It was a small stack.
And did you look through every one of those? Just glance
Not
through
every
them?
one of them.
I'm sorry?
Not every one of them.
How many?
Probably about 4 of them.
4 of them? You remember giving the report that you just gave a couple of days ago when you first talked to the defense on September 6, 1993?
Yes.
And do you remember telling them that you looked,
Counsel.
page 3, first paragraph?
See if I have a, okay.
Did you tell them that you had looked through some magazines in the library and looked at one of them?
No.
Okay. Would it refresh your recollection to take a look at this report?
Objection, Your Honor, witness hasn't indicated a need to refresh recollection.
Would it refresh your recollection to take a look at the report of your interview with the defense on September 6th, a couple days ago?
Okay.
Okay. May I approach, Your Honor?
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
Does that refresh your present recollection about what you did in the library?
Yes, but I keep thinking about what I saw, and I, remembering back at that time, and maybe I remember a little more about it,
Okay, so you remember what?
I, just looking through them because I didn't want my child to go in there and see them.
Now, your children had been in that room.
Yes, they were all over the house.
Okay. And they had been cleaning up in the room?
Yes.
I'm going to object, Your Honor, as vague as to when.
Do you know how the magazines got there?
No, I don't.
You don't know whether the defendants brought the magazines there, do you?
Objection, Your Honor, calls for speculation.
No, I don't.
I have nothing further at this time, Your Honor.
Mrs. Dominguez, was it your understanding that Mr. and Mrs. Menendez were living in the master bedroom? Would be living in the master
Yes.
bedroom? Not the sons?
No.
And when you worked at that house for Mr. Slotkin, is it your testimony that you and the others removed everything there that you found?
Yes.
And you even packed up furnishing magazines such as Architectural Digest?
Yes.
And those, to the best of your knowledge, belonged to Mr. Slotkin?
Yes.
You didn't find any pornographic magazines when Mr. Slotkin lived there, did you?
No, I didn't.
Is the first time that you saw these pornographic magazines after the Menendez possessions arrived at the house?
Yes.
Now, do you know when it was that Prince or Elton John rented that house?
No, I don't.
And were you aware that the macho rock band U2 rented the house last?
Yes.
And when Mr. Slotkin rented this house, he rented it furnished, did he not?
Yes, he did.
And it had many personal possessions in it of his that he left for his tenants?
Yes.
And it's that in part that you were packing up?
Yes.
And was it your instructions to take everything out of the house before the Menendezes moved in?
Yes.
And with respect to Mrs. Menendez, were you there both to clean and to help unpack?
Yes.
And did you unpack similar looking boxes to the one that had the magazines and videos?
Yes.
Did they all seem to be the same type of box?
Yes.
I have nothing further.
Anything else?
Yes, thank you. Ma'am, you just testified that you're instructed to remove everything from the house. Is that right?
Everything that they didn't purchase, the
Well,
family was purchasing.
Which
But
means
not furnishings because they had men to remove all that.
But didn't you testify on cross-examination that the Menendezes had bought things from Mr. Slotkin, and so those things would presumably be left at the house?
Yes, it was maybe some type of furnishing that was left.
Thank you.
Anything else?
I know you're
All
on.
right, thank you. You may sit down. You're excused.
Thank you.
Let me see counsel at the sidewalk. And the next scheduled witness will be at 1:30. So I'm going to excuse you in just a moment, all of you. But before I do that, it's been a while since I spoke with you. So let me do that at this time. First to the gold jury, and then I'll ask the same questions of the blue jury. As to the gold jury, have any of you seen or heard anything about this case in any form whatsoever outside of the courtroom other than what you've already told me? All right. Have any of you had occasion to watch the late night TV show, The Tonight Show with Jay Leno? All right. Anybody? No? Okay. Everyone's asleep at that hour. Okay. All right. And let me remind you not to discuss this case among yourselves or with anyone else, and don't permit yourselves to be exposed to anything about this case in any form whatsoever. And we'll see you all back here at 1:30. But before you leave, let me talk to the blue jury in the same form. Have any of you been exposed to anything about this case in any form whatsoever outside of the courtroom other than what you've already told me? All right. Any of you have seen the Jay Leno show in recent times? Okay. All right. We'll see you all back here at 1:30 as well with the same admonition not to discuss the case with anyone or form any opinions about it. The jurors have all left. All counsel are here but Ms. Abramson. But let's first deal with matters that concern Lyle Menendez. Are there any matters that counsel for Lyle Menendez wish to discuss before we excuse you?
We need to address one matter in camera. We need to update the court on that issue.
Okay. Other than that, is there any matter that you wanted to discuss? Right. Let me go back. After we recessed yesterday, I was thinking about a couple of the issues that had been raised by the defense relating to the cross-examination of Lyle Menendez. And let me just go over them again. I think, in essence, at least one of them had been deferred until such time as the examination commenced, the cross-examination commenced. Regarding the movie, the BBC movie in reference to it, I did indicate that the examination of Eric Menendez, if done before the Lyle Menendez jury, could very well touch on that subject and would bring that subject to the attention of the jury at that point. And it seems as well during cross-examination, if the people chose to do so, they certainly have a right to explore those matters that are within their knowledge of what possibly was the genesis of the plan to kill the parents, and could ask questions along those lines. I certainly can't see how I could foreclose that or that the defense would have any legitimate objection to that in the context of a cross-examination.
I think we still have the same difficulty that we had with it before, which was the references in the November 2nd session that he did not allow me to say is something that the prosecution was able to ask Dr. O'Zeal about in front of our jury. They chose not to ask him about it in front of our jury. Had they, we could have cross-examined in terms of what the context was of the statement, who made it, etc. They didn't elect to go into that material in front of our jury, although they had it. So our position is that it is similar to other situations where they had a witness who could have testified about the material and chose not to elicit it. And so they should not be permitted to do it now in cross-examination, much as they had Valerie Hart on the stand and Mark Heffernan on the stand about their issues. If they made an election not to go into it, the witness who supposedly heard the statement and could give it some context and meaning, that it is unfair now to produce it for the first time as a question on cross-examination.
Well, I don't know exactly how the questions are going to be phrased, but it seems to me that this would be an appropriate area of examination. I don't recall the specifics of what it was that was allegedly said by Eric Menendez in Lyle Menendez's presence to O'Zeal that has not been brought before the jury. You can point that out to me in the statement of O'Zeal. My recollection is, and if not based on the specifics of that statement, just in the context of how the trial has progressed, my recollection is, or belief is anyway, that the defense probably objected to the receipt of that evidence anyway.
Admissible.
Right.
And the people were elected not to ask the question.
Okay. But again, that could very well be just a decision on trial tactics, and this doesn't amount to the concept of sandbagging that has been the nature of your objection.
Well, it would be our position, Your Honor, since motive is really the only issue in this case, and that speaks specifically to motive, that it is sandbagging, that it is the core issue of the case. They had the witness on the stand who allegedly heard the statement, and they chose not to ask him in front of Lyle Menendez's jury about that statement, who said it, what was said in response to it, what preceded it, what followed it. They made that election. And now to just
asked Lyle Menendez in front of his jury, what about this? When they never produced the evidence and they had it. And I think that there is little in this case that's more germane than that type of question, because it speaks specifically to motive. It's sandbagging.
Well, except that at this stage anyway, the evidence is not before the jury that Eric Menendez said anything to Oziel about it in Lyle Menendez's presence. So the Lyle Menendez jury doesn't know anything other than perhaps a question asked of Lyle Menendez and his statement, yes or no, it was said or not said.
Judge, the November 2nd session contains this passage.
What page?
This is page 11. When I asked why they killed their mother, since it was apparent to me why they had killed their father, they claimed that once they began seeing the plot to a BBC special that mirrored what they intended to do with their father, they simply included in the plans a plan to kill their mother because their mother would have been depressed and suicidal in any event if they killed their father. So in other words, that's a statement by Lyle Menendez on the central issue in the case, which the people, for whatever reason, did not put into their case in chief, and now want to bring it in through cross-examination. It seems to fit within the case as talking about specifically confessions as being the subject of the sandbagging rule, that it's improper to withhold something as devastating as a confession and bring it out late in the case through cross-examination or rebuttal.
I don't see it on page 11. Maybe I'll look at it.
Page 11 of the tape transcript, Your Honor.
I have that.
Maybe you have a different version.
I have the one that we used.
Paragraph, the beginning of paragraph 3.
It may be different.
Paragraph that starts with, the boys both.
Okay, I see that.
Yeah, it's-
Okay, I see it. Okay. Okay. A situation where an entire confession has been omitted from the people's case in chief. It's only one small snippet of the overall conversation. But let me, if you feel that there are cases that deal with this particular subject that would be controlling.
I do, Your Honor. There
Okay.
are cases specifically dealing with whether the prosecution can withhold an incriminating statement by the defendant and bring it up in rebuttal or cross-examination. That case on it is People versus Thompson.
Okay, well, let me do this. You can just sort of write out the names of the cases and the citations, and I'll look at them. And briefly, what is the people's response now, or do you want to defer that until I look at the cases?
When Dr. Zill was testifying, we did not know what BBC was. And first of all, the case that I cited before, which I think cites Thompson, is a Supreme Court case that says that the people may not withhold a material part of the case. For the defense to characterize this portion of the entire Dr. Oziel statement as a material part of the case, when at the time that we presented it had no meaning, is to be stretching the Supreme Court's opinion as to what constitutes sandbagging.
Okay, why don't you just give me those cases? I'll review them and I'll defer ruling on this. This is something that could arise. And we'll deal with it prior to it being brought out.
Also, along those same lines, Your Honor, it was my understanding, although the Lyle Menendez defense team was not present for this controversy, that the court did impose some restrictions on the prosecution expanding the reference to BBC into their interpretation that it was the Billionaire Boys Club. And it was saying the court ruled that they could not do that. I'm wondering whether the same restrictions would apply if the court held this to be proper cross-examination.
No, the ruling had to do with the stipulation relating to Detective Zoller. It was actually his testimony rather than stipulation. Detective Zoller's testimony to the jury that there was such a television show during a time frame that could or could not have relevance to this case. And it had the title BBC. And the court foreclosed reference to the Billionaires Boys Club only because Oziel did not refer to the Billionaires Boys Club. There was just reference to BBC. So at this point, without knowing what the specifics of the direct or cross examination will be, I can't rule on anything more than that. Oziel did not refer to Billionaires Boys Club, so there was no relevance to Zoller being permitted to testify about that. But as far as cross-examination, I at this point can't foresee precisely what is going to be said, so I can't rule in advance as to what might or might not be asked in that regard.
I guess our objection would be that the people have to have some good faith belief that there is evidence to suggest it was the Billionaire Boys Club, and the only evidence we're aware of that they possess is a statement by Dr. Oziel, which does not specify anything more than BBC. And it's our position that that inflammatory line of cross-examination should be based on the good faith belief that that, in fact, was the movies that was being talked about. And other than the speculation of the prosecution, I'm not sure what the factual basis is.
Well, as perhaps my recollection is imperfect, but I understood anyway that the prosecution would not be going into the Billionaires Boys Club per se during the cross-examination of Lyle Menendez, but would reserve that for Eric Menendez. Am I correct or incorrect in that?
I think we talked about the specifics in front of each separate jury, but the generalities
In front of both. That was, I think we discussed that yesterday.
All right.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
It would have to be dealt with on a question and answer basis and with offers of proof. And if this is an area of concern by the defense of great prejudice, then prior to it being explored by reference to the exact title, Billionaires Boys Club, we can have a brief hearing. But I can't really rule any more than that. It would be, yeah.
And that is that because it was elicited only in front of the Eric Menendez jury, I remember very specifically Mr. Kuriyama's redirect examination of Dr. Oziel, in which Dr. Oziel made reference to the British Broadcasting Corporation, specifically, rather than Billionaire Boys Club, as that being his understanding of what the BBC reference was. Clearly, that was never in front of the Lyle Menendez jury, and so it's going to complicate areas tremendously if all of a sudden there's not only the questions about the BBC, but then the attempt by the prosecution to suggest that it's the Billionaire Boys Club when Dr. Oziel himself seemed to think it was the British Broadcasting Corporation.
I would suggest then, if you could find that reference in the transcript, it might be of assistance in dealing with whatever comes up during the Lyle Menendez cross-examination. The other area that came to mind after we recessed yesterday had to do with the reference to the Calabasas burglary. I've already ruled that these burglaries are not usable by the prosecution for impeachment under the Wheeler rationale, and I've analyzed it under Section 352 of the Evidence Code. As far as a Calabasas burglary, however, and counsel can refresh my recollection dealing with Oziel's notes, whether or not there was reference by Lyle Menendez to the so-called perfect crime and criticism by the father, and specifically those things as motivation for commission of the crime. And if so, then whether one categorizes it as 1101 of the Evidence Code evidence or some other motive evidence or evidence of state of mind, it could have relevance in that regard. So that's a separate issue, and was the basis of the court's rulings in regards to its admissibility for Eric Menendez. So the analysis would be different in regards to Lyle Menendez than the analysis that relates to impeachment under Wheeler. I don't have a clear recollection now as to the specifics of Oziel's statement in that regard as to whether there was reference by Lyle Menendez to the Calabasas burglary. Well, not whether it came in, but whether there was in the statement And if it didn't come in, maybe it's in the same category of objected to evidence that the defense feels is covered by their objection that this should have been brought out during the people's case.
It is in the notes on page 12, the last two paragraphs. In fact, it's Lyle Menendez who initially broaches that subject of the Calabasas, what he called lobbying.
And that was not introduced. This is on page 12. That was not introduced by the prosecution.
It was introduced as to Eric Menendez.
No, we had a big hearing, that was part of the adopted admission hearing where the people indicated they were only seeking to introduce it against Eric. And I think I made some kind of equal protection argument at the time. And they just chose not to use it against them.
Yes.
I believe that there were a number of topics which had been limited that were later expanded or put in front of both juries through cross-examination. And I'm going to have to review Dr. Oziel's cross-examination to see, because I remember that there were several topics which we had delineated as being for one jury or the other, which then were placed into issue in front of both juries by virtue of cross.
Well, if that occurred, then certainly if you can find that.
Yes,
it
I'll
would,
have to look this weekend for the.
all right.
Our recollection is that it did not occur. We're keeping very close watch of that issue. There is no evidence in front of Lyle Menendez jury concerning this incident. And the court is correct that our position with respect to this statement is the same, that it's improper rebuttal cross-examination, because from the face of the statement, it does appear to be Lyle Menendez talking about motivation for the killing.
Okay, give me those citations and then we'll review them. And these will be issues that won't be brought out until further litigation and noticed by the prosecution. So before we close the courtroom for the brief hearing that counsel have, let me hear from the defendant, Eric Menendez, on your issue that you wanted to raise.
Yes, Your Honor. With respect to putting on the Eric Menendez defense, it was our decision and our desire that with respect to the defense in this case, that our jury hear it from Eric Menendez and not from Lyle Menendez, and that they hear it at a minimum from Eric Menendez first. And our position is that we are not calling Lyle Menendez. We do not want him to testify in front of our jury. Well, we certainly don't want him to testify before Eric has had an opportunity to tell his jury about the events of August 20th and the years before. And our position is that if the people wish to have a basis for calling Lyle Menendez in rebuttal to what Eric Menendez testifies to, that would be the appropriate place in the scheme of things for Lyle Menendez's testimony to be exposed to Eric's jury, but not before Eric himself has had a chance to address that jury. And we did not make a joint decision that Lyle would testify first in front of both juries. Our decision was that Lyle would go first in front of his own jury, and then Eric would go first in front of his own jury. And that order of witness has been destroyed to our detriment, because Lyle's way of talking about this case and Lyle's specific motivations, as Ms. Lansing pointed out yesterday, and Lyle's mental state may or may not be the same as Eric's. And yet Eric's jury is going to hear for the first time about these events through the prism of Lyle's testimony. And we think that prejudices the Eric's ability to testify before his jury in the order and sequence which we feel makes the most sense for them and maximizes the defense.
Perhaps,
Well, let me hear just from the defense side, and then we'll go back.
Could I add Lyle Menendez at this point, which is yesterday the court dealt with the Brooks versus Tennessee issue insofar as it related to the prosecutor dictating how we would conduct the direct examination of Lyle Menendez, and the court indicated that we would be entitled to order that direct examination in any reasonable way that we saw fit, subject to the court's discretion. The Brooks versus Tennessee objection that Lyle Menendez is raising now, and also Eric, it goes to a broader issue, which is whether the prosecution can dictate calling the other defendant during our case. And that seems to be a greater intrusion than ordering the direct examination that we were talking about yesterday. It's not for Lyle Menendez a matter of timing. He has the advantage of going first. But as for Lyle Menendez, the issue is, should the prosecutor have the right at all to dictate that Eric Menendez be part of his defense case? And that's what they're doing. Regardless of when they put him on, they are intruding into our defense presentation in a way which we say is contrary to the principles of Blitz versus Tennessee.
All right, let me hear a response from the prosecution.
Yeah, I have just a brief comment about Brooks versus Tennessee in that that's a case where the court indicated the defendant would go first or not at all. That's not what this court has indicated.
No, I think that was actually a statute in that state.
But nevertheless, the court is not indicating that it's testifying now or done at all. It's just that the court's indicated there shall be no further witnesses on these topics we've already had unless they and until they become relevant. And so it's time to either make them relevant or rest. I mean, I think that's what the court's saying. It said the witnesses that have been offered before the testimony of the defense, I think the court's found were not relevant unless and until the defense testifies. So it's not like the court's telling them they have to testify now, but just that the other witnesses are not relevant unless they do testify.
That's a separate issue from what the defense is arguing. What I indicated yesterday was that, and this is the third time I will be saying it, I'm not telling the defense when the defendant should testify. All I have ruled is that those three witnesses that the defense intended to call, the three therapists for the mother, would not have relevant and admissible evidence unless and until the defense establishes that relevance in some fashion, whether it's through some eyewitness to the crime or to the shooting or some other way. And the nature of the defense presentation has been that the next scheduled witness after those three therapists was the defendant, Lyle Menendez. So that's how we came to be at this point. But that's not what the defendant has been arguing today.
I understand, and he's also saying that we are dictating that the defendant shall testify in front of both juries instead of their own juries. I mean, that's the point I think they're making. And it's up to we're not dictating anything. We've made our position known. And it's up to the court to control the proceedings and the process of the witnesses. So it's just been our position that they should testify. We're having a single trial and that they should testify in front of both juries.
All right, well, that has been your request that they testify before both juries.
Yes.
All right, the situation is basically one in which if this had been theoretically separate trials and one defendant had been tried and convicted and sentenced and his appeal had been resolved and no jeopardy attached to his situation whatsoever, he could be called as a witness in the people's case in chief against the other defendant. And in essence, really, is it any different than that the people are being permitted to call a witness out of order, that being the other defendant to testify in the other defendant's case. And had it been done during the people's case in chief, it would have been done at that point. But it's being done here at this stage of the proceedings. That's one observation. Another observation is the defense contention that the witness could be called in rebuttal by the prosecution. But in order to conserve time, resources, and for the efficient use of the judicial resources here, rather than have one defendant testify twice to the same matters, the court feels that it's appropriate for that defendant to testify once before both juries rather than being called back as a rebuttal witness. And the court is also of a view that based upon the nature of this particular case, the proffered defense that has been presented throughout and has been announced and reiterated throughout the course of the trial, that it is a joint defense and that the issues that are the same as relate to both defendants. There's a commonality of conduct and experience, and that the defense feels and has argued that the jury should have all this information from day one to evaluate the totality of the circumstances to make an intelligent decision as to what happened. It seems to me, in the interest of justice, the jury should be permitted to hear both defendants. We have taken great care to isolate those matters that would be prejudicial to one defendant when the other defendant is testifying, and the record is replete with those efforts. We've spent a great deal of time in that regard so that prejudice would not arise from the procedure that we're using. Anything else? Yeah.
I'll argue with the court, but just to clarify our position in regard to the rebuttal prospect, the prospect of calling Eric Menendez or Lyle Menendez in rebuttal, I just wanted to clarify that it's not our position that we are conceding that the scope of rebuttal is exactly the same as it would be if the people are allowed to pursue their suggestion. And our mention of rebuttal was on the assumption that the court would then be in a position to determine what was proper rebuttal. And at that point, it was going to be our position that if the testimony was not inconsistent, that we would be objecting that it was improper rebuttal. So I didn't want the court to get the impression we were suggesting it was just a matter of timing and we were conceding that they could call him in any event and examine our rebuttal on a full range of testimony that they conceivably could if they were doing it through the proposal or suggestion.
Okay, I understand that. And my ruling here and the impending testimony of one defendant in front of both juries and subsequently the other defendant before both juries with the limitations that we've outlined and the procedures we're going to utilize is going to be the ruling of the court here. All right. Then we have briefly a matter to deal with Lyle Menendez. So let's clear the courtroom and deal with that, and then we'll proceed.